Good morning, folks. Jeff Robbins here, Chair of the Colorado Oil and Gas Conservation Commission. This is day 2020 of our rulemaking hearings. At least it seems that way. We're getting close to the end. Really appreciate everyone's participation. I see folks are flowing into our rulemaking. We have 63 participants so far. We will start today with a roll call of the commission. Hearings Manager Larson.
Thank you, Mr. Chair. Commissioner Gibbs.
Here.
Commissioner Gonzalez.
Here.
Commissioner Hackett.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Excellent. Thanks everyone for being with us. We're now at 74 participants, so appreciate all of Colorado paying attention to what we're doing and being a part of what we're doing because it's very important. To start off the day, I would look to any initial comments from my fellow commissioners at this point. Commissioner Gonzalez.
Yeah, thank you, Mr. Chair. I just wanted to make a brief comment on the CBS4 article that came out earlier this week. And so I prepared a little statement that I'm going to read that reflects kind of my feelings on the situation. So having considered that situation regarding the fake names used in the COGCC's test filing system, I want to share just kind of my thoughts on that. You know, as acknowledged by Chair Robbins and Directors Murphy and Gibbs yesterday, the names were inappropriate and unprofessional. I agree wholly. I believe that some of the names perpetuate stereotypes of the oil and gas industry, and they're stereotypes that I know to be untrue. However, in my time working with COGC staff in this new role over these last few months, I have not experienced anything to suggest that this agency is biased against the oil and gas industry. And as I've stated in this forum many times, I continue to be impressed by the hard work and dedication of this staff in finding workable solutions while fulfilling the mission of this agency. I have faith in Director Murphy and her leadership team that they will use this as a learning opportunity and will ensure that the Colorado oil and gas industry is treated fairly and impartially. So that's kind of my thoughts, and wanted to share that with everyone listening in today.
Thank you, Commissioner Gonzalez. Appreciate those thoughts, in particular from your perspective as being the industry rep on our panel. Very thoughtful. Yeah, all right, well, we'll move on to next issues. Are there any commissioners with initial thoughts about the wildlife rulemaking that we're going to try to conclude up today? It's been a massive effort. It's been a long time in the making. Commissioner Gibbs.
Thank you, Mr. Chairman. Commissioner Gonzalez, thank you for your comments too. I just wanted to reflect a little bit. Today we are going to be, moving into deliberations with the 1200 series. And, these series have definitely been really near and dear to my heart for many years on wildlife issues and challenges, looking at wildlife habitat and protection. As some of you know, I'm a former legislator, and I was elected in 2006. And this was actually one of my late bills, but a few days ago, you recall seeing the side-by-side comparisons of House Bill 1298 and Senate Bill 181. Well, that 1298 was my bill. And so, I remember vividly working with many of the stakeholders that have testified, before this hearing. I worked with, industry partners, conservation groups, and it was really the first time for 1298 that, Parks and Wildlife really was able to have a seat at the table when we're looking at oil and gas development. Believe it or not, the bill, passed. But we were able to work, closely with all the different stakeholders. I was originally looking at having very prescriptive language, and then decided to have more of a rulemaking process to get more input from everyone. It caught the attention of Washington, D.C. I was actually able to fly out to D.C. and testify before Congress and the subject title was called Denied, the Growing Conflict Between Hunting, Fishing, and Energy Development on Federal Lands. And I remember the day I was flying out to DC, there was like an article in the Denver Post that said like, Mr. Gibbs goes to Washington. And it was pretty crazy to say the least, because especially being a new legislator working on a bill that I had no idea was going to be so important to people, whether or not you work in the industry or you're a hunter and angler. You know, my first committee hearing for that, the whole committee was just filled with folks in camouflage and blaze orange. You know, I had a lot of the hook and bullet crowd, which I'm one of those folks that love to hunt and fish. So it was exciting to see that support, but also was able to get, you know, and garner support from oil and gas industry too. But, you know, as director of the Department of Natural Resources, it's really my role to help, you know, protect all of Colorado's natural resources. And it's critical to balance, you know, what we're able to achieve, and especially look through the lens of Senate Bill 181 to help protect public health, safety, welfare, our wildlife, and environmental resources. I'm really glad to see the latest efforts, you know, and hearing from stakeholders and staff that we are working hard to achieve what legislator leaders and Governor Polis, now under Senate Bill 181, wants us to work on. You know, I know that we are going to be, you know, having discussions today on what, you know, the proper setback should be, on whether we're looking at, you know, 300 feet or 500 feet and so forth. And these are really important discussions. But I feel really good about the place that we're at right now. It just reminds me so much of House Bill, you know, 1298. You know, we need to recognize the importance that oil and gas industry has in the state of Colorado, 89,000 jobs, but also, you know, recognize the importance of hunting and fishing in our natural resources. You know, hunting and fishing bring $1.8 billion and thousands of jobs to the table too. But it doesn't have to be one versus the other. You know, we can coalesce, we can work together. And I just want to commend you commissioners for really working hard to try to find that sweet spot, because I know it's not easy. And I'm just really proud and happy to be a part of this team, you know, working together as we try to finalize, you know, what this looks like moving forward. But on behalf of the wildlife in the state of Colorado, I just want to, you know, thank you for really working hard to try to get this right.
Thank you, Commissioner Gibbs. Thank you, Director Gibbs. Thank you, Jimmy Stewart, for the work that you've done with regard to going to Washington, and for all of this, because it really is, it's a really cool story. And it, you know, I think that what we're undertaking here does, you know, is based upon that initial work back in 2008 and your bill 1298, and we're advancing it. I've had some great discussions with some of our stakeholders. I was involved as a local government lawyer on 1298 in the implementation, represented a lot of local governments back then. So it's been kind of a really, I think, good story. And the thing that I find really unique about the work that we're doing today is is indeed the consensus that we're able to build. You know, yeah, we've still got some sticky wickets to get through today, but there has been, out of 99 parties, some tremendous consensus. And so I think that's unique to Colorado. We're leaders here and we're doing a good job. So thank you again, Commissioner Gibbs, for those opening remarks. Any other initial thoughts? Everybody ready to roll up your sleeves for the good work today? All right, well, I think that at this point, we have heard closing statements from all parties. I would like to turn to AAG Davenport to make sure that we have taken care of all the procedural nuts and bolts, dotting of I's and crossing of T's. AAG Davenport.
Thank you, Mr. Chair. Commissioners, we need to make two motions, as the chair mentioned, to make sure that we're in the right spot procedurally. The first motion is to continue this 8, 9, and 12 rulemaking to, I will recommend November 25th, since that's been our practice, just to be safe, to continue that rulemaking to November 25th. The last time this commission continued this rulemaking, it continued it to today, and I know now the plan is to have final votes on Monday. So the first motion is to continue this 8, 9, and 12 rulemaking to through November 25th.
AG Davenport, does that motion need to specify the rulemaking docket number? Because I don't even have that in front of me. Or can we just be so cavalier as to say 8, 9, and 12 is continued to November 25th?
I think 8, 9, and 12 rulemaking is sufficient.
Do we have a motion? Commissioner Messner.
I just have a question, and I'm sure that it's appropriate, but is it okay to continue the hearing to the 25th and still have deliberations today, or do we need to wait till the end of deliberations today to continue the hearing?
It's appropriate to just continue it right now.
Okay. So I can move continuance of, and it's just the 8, 9, and 12, right? All three, hearing until November 25th. Do we need to have a time certain, or
No.
just the 25th? Okay.
Second.
We have a motion. We have a second. Discussion. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Okay. The second motion, AG Davenport.
Thank you, Mr. Chair. The second motion is the last time this commission met to discuss the 2 through 600 rulemaking, it adjourned until this morning. And I don't believe the plan is to have discussion about 2 through 600 rulemaking today. And so all we need to do then is to acknowledge that we're opening up that rulemaking and then move to adjourn that rulemaking until, I believe the plan is 9 a.m. on Monday, November 23rd.
Okay. Do we have such a motion?
So moved.
We have a motion and a second. Further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Motion carries. All right. It's 10:13. Now we get to roll up our sleeves on the outstanding issues that exist before us with regard to the wildlife series. I'm going to pick on Director Murphy to see if she can lead us into this discussion.
Thank you, Chair. So if I reflect back to our conversation on Wednesday, I think it really focused on 3 major issues. And consistent with my remarks on Wednesday, I would start with the kind of general question of process for siting within 1202C habitats. Is that an exception? Is that a variance? Staff has been pretty consistent that we think variance is appropriate. Industry has been very consistent that they think an exception process is more appropriate. So that to me is kind of the status. I think we heard from a number of the environmental organizations yesterday that variance is the right one. So that's the big picture 1202C1. As we delve into 1202C habitats, there is a question of addressing the aquatics. And that to me is a subset of the question. And, you know, is it 300 feet? Is it 500 feet? Is it more? That's where we have kind of that matrix level choice. I continue to recommend that you address the bigger 1202C question first, so that you know when we get into the aquatics habitat, what are we comparing against? I think it'll be awkward. It'll be hard to do it in reverse in terms of an exception process. The third significant issue that we discussed on Wednesday is compensatory mitigation fee. Is it the right number? And I think that there are 2 subparts. Is it per acre? Is it a flat fee? And is the dollar amount correct, depending on whether you pick per acre or flat fee? I think that there are also issues that other parties brought up yesterday. Because I am not those parties, I'm not going to try to summarize them, but I'm sure that you commissioners have thought about them and may want to talk about some of them. So those to me are the big three, and also an acknowledgement that there are others.
Thank you, Director Murphy. Appreciate framing the discussion that way. Yes, I anticipate my commissioners as well have a few more one-offs on the list from the last few days of evidence and testimony. But I agree that those three are perhaps the sort of the bigger issues that remain outstanding. And I encourage discussion amongst commissioners in the format and under the framework as you have indicated, so that we are thinking about variance, exception, and then aquatic, and then compensatory mitigation. My thinking around variance exception actually sort of embraces some of the aquatic piece at the same time. So I kind of have a little bit of an ability to think about both at the same time, because my mind has them interrelated in terms of variance for some, exception for others. But I will allow others to provide perspective. I'm happy to provide my perspective as well. I've got some pretty good thoughts on this as well, but I don't want to disengage from other commissioners, and I know there's been a lot of thoughtful comments about this. Commissioner Nanchapa. I was hoping you were going to raise your hand, Commissioner Nanchapa.
Sorry, and I really don't, I feel very confident that the ideas that other commissioners have are going to be, just excellent. But I actually had a question. So with what you just mentioned, Director Murphy, and along the lines of what Chair Robbins just said, if we're thinking of something that might include an exception or a waiver or something, in particular for the aquatics, does it make sense to separate these out into separate subsections, into kind of, one set and another set that's more specific to aquatics, maybe even terrestrial and aquatics, even if we have differences within the aquatics? I'm just thinking about this in terms of, structuring the rules, and I don't, maybe we don't need to go into this depth right now, but I was just based on your comment, I just wanted to make sure, given that you were saying if we're deciding whether there's going to be a variance or an exception, and if we don't necessarily want it to apply to all, do we need to create two different categories?
Dr. Murphy.
I think it'd be helpful for me to make substantive decisions and then think about how that works in terms of developing clear rules. And I mean, I'll probably volunteer Joel to be like, dear Joel, does this still work together in the framework that you wrote for us months ago? But Joel, that was not a call to like pop up at all. It was just a dire warning, perhaps.
And I think some of it's going to depend upon Commissioner Njapa, where we have consensus around some of these things in terms of how this lays out. So I think I'm sort of thinking we kind of need to all sort of start spilling our guts out in terms of what we think is the right approach, with regard to these issues. And then we can kind of feel each other out and determine, okay, do we need two different rules? Do we need one rule? Is it one process for one? Is it another process for another, et cetera? Commissioner Gonzalez.
I saw Commissioner Nanchapa's hand pop up right alongside mine. So if she wants to give her pitch, I'm happy to hear it. I've given this a lot of thought. I too kind of I've had a hard time separating the actual distances from the waiver variance discussion, but I'll capture this with X and Y distances. How about that? I don't know if that's helpful or not. We can kind of fill in the blanks as we go. But I had about 8 bullet points that I put together for 1202C on kind of the waiver variance that took into consideration kind of the framework that Commissioner McGowan pitched, and then some of the feedback we heard on that framework from various parties yesterday. And so I'm just going to walk through it. You know, it's not right, it's not wrong. It's just kind of the pitch that I came up with, and hopefully it's a good starting point for discussion. It's going to capture a few different ideas in here. So, so if you need me to stop at any point to, you know, to talk through it, interrupt me. I don't mind that at all. But with that, I'll kick it off. So I'm thinking of kind of a hybrid approach with a separate NSO and a separate waiver distance. So X and Y, whatever those are. I think a separate distinction for gold medal waters with a stricter NSO. I personally think that the all three aquatic layers should be treated the same. So that includes cutthroat trout, along with sport fish and native species. That obviously contemplates an intermediate buffer. And with that intermediate buffer, I would suggest adhering to Rule 411 A, 2, B, and the Romanets 1, 2, 4, and 5, because I think that third one about daily inspections may or may not be appropriate, but whatever that frequency is, I think that's something to be discussed if that's something we want to highlight in the rules. I would like to see clear guidance in the SBP related to the ability to waive 1200 series buffers under 309E, 3C, and D. I put D kind of in a question mark there. But basically that's where the habitat doesn't exist, or the species is not present. The next part is clear guidance in the SBP about how elements in 502C, specifically elements 1 and 3, cannot comply, good faith to comply, and undue hardship will be administered in a variance proceeding for 1202C.
Okay, sorry. Could you say
Sure,
that
yes,
again?
Commissioner
Sorry.
Gonzalez, I need you to say that one again too.
No problem. So that was clear guidance in the SBP about how elements in 502C, namely elements 1 and 3, so 502C 1 and 3, the cannot comply and the undue hardship elements, how that would be administered in a variance proceeding in 1202C. So something in the SBP that says, hey, that the commission is going to consider this under these circumstances for good faith. This is what this means when it comes to wildlife, based on the deliberations that we've had so far, and how we can kind of make that workable if that's the route we go. And even if it's not, I think it's appropriate in general for this particular series. The next one is clear guidance on explaining the potential efficiencies on the concurrent variance review along with the OGDP application. I think if we set that out with appropriate guidance in the SBP that captures our deliberations and our intent there, that could give some more comfort in how people are going to be working through that variance process with or without, you know, kind of an intermediate buffer waiver. The next one is a rule mandating CPW consultation as a prerequisite to the variance application, meaning that if you're going to submit a variance for 1200 series, that you have consulted with CPW first. Otherwise, I think it might be a waste of time for both COGC staff and the operator. So I think it's a good practice, and I don't see any harm in codifying it or mandating it. And then something that is kind of new to this discussion that I thought about last night in regards to how we regulated setbacks under 604 is an additional way to encourage caps. And I think Mr. Chiropoulos' testimony late last night was influential for me on this. And basically look for a waiver consideration for any pre-cited locations for caps similar to what's cited in 604B2. And I can read that for everyone. It's basically the location is within an approved comprehensive area plan that includes preliminary siting approval pursuant to 314B5 or an approved comprehensive drilling plan. So just a way to continue to incentivize that cap process, that landscape level planning. And then my last point is specific to federal decisions and a kind of a carve out waiver just limited to the BLM. And that waiver is adopting Kinder Morgan's first pass language that they suggested for a new 309E 5D Romanet 3.
Say that last one again, Commissioner Gonzalez.
So a separate waiver provision for federal decisions that contemplate interaction with BLM permits. that was the additional language suggested by Kinder Morgan, and they suggest it as new rule 309, lower E 5, upper D, Romanet 3.
And was that Kinder Morgan preferred or Kinder Morgan alternate?
I think the Kinder Morgan preferred is the appropriate way to go. And I was persuaded by some of the testimony about kind of the limitations on participation at the variance level by the BLM stakeholders. And so that's one of the reasons why that was influential to me. So that's kind of my big, my big pitch, if you will, or just my ideas. So I'll leave that as a jumping off point for the rest of this conversation.
Commissioner Nanjapa?
Thank you, Mr. Chair. And thank you, Commissioner Gonzalez. I think there's a lot of agreement with what I have been thinking about in what you just presented. And I'll say in particular, I'll pause on the aquatics for a moment, but the guidance in the SBP about the variance process as it relates to this series with 502, I hadn't specifically thought about this, but I really like the idea of CPW consultation being a prerequisite when seeking a variance on any of the 1200 series provisions. I also had a similar thought related to the comprehensive area plans. I had some thoughts earlier on, and then I think in part because it hadn't really shown up as much in some of the stakeholder testimony that I kind of dropped it off, but I agree with you that some of the testimony from Mr. Chiropoulos yesterday kind of brought that back to the fore for me as well. And I do think that landscape level planning is going to be really helpful. Even out, and I think our two existing CDPs right now are in the Front Range, or at least one of them is. But I think it will be really helpful in the Western Slope as well, and can contribute to a variety of opportunities to both, to have, the balance between the habitat protections and the development opportunities in a very protective manner. So I appreciate all that. I also agree with including the primary request from Kinder Morgan. I think I looked back through and talked to Kyle a little bit about this, that I don't believe we have a way for them to do that in our rules already. And it did influence me that in going through the process with BLM, the opportunity to understand whether or not CPW is going to approve earlier on is not as clear, at least in our rules, and also provides them that advantage to move on if CPW says it's not going to work. Did you have an opinion on any of this stuff?
No.
Okay. All right. Just checking. Okay. So all of that being said, in the aquatics pieces, knowing that we already have the provision in 309E3C for whether or not there's habitat, present, knowing that we already have the waiver for intermittent and ephemeral streams in 309E51, I think it is. I am feeling that we need to maintain the aquatics at 500 with the variance for all of them. I would recommend putting gold medal waters in with the cutthroat in Q, and having those waivers as we already have them applicable to RNS, again, for the intermittent and ephemeral. And then again, it would apply to any of them if the habitat was not available per 309E3C. And all of this is in thinking about this with respect to the way the process works, the opportunity for pre-consultation already within high priority habitat, the desire to avoid and protect this habitat, given that it is very sensitive. And then the last thing I would say is I did also like the well, let me say, so in a variance situation, I would want the 411 A2B provisions to apply. And I appreciate what Commissioner Gonzalez said with, perhaps accepting out Romanet 3. And so I think in that case that could happen. I would prefer a hard 300-foot buffer, 300-foot NSO in any situation. So in other words, the variance would not apply for these habitats below 300 feet. That would be my preference. But then I also appreciated the suggestion from the wildlife hunting and angling groups of any time we're 1,000 feet or there's development going in 1,000 feet from any of these high priority habitats of the aquatic habitats that we put in the 411 A2B provisions. So that's my laundry list.
Thank you, Commissioner Nanjapa. Thank you, Commissioner Gonzalez. I can weigh in a little bit on some of this. I'm in somewhat agreement with some of the things that you're saying. Just to make a couple of statements, I've gone back and forth on waiver versus exception and on the sub 1 and sub 3, the can you prove it and the undue hardship. And I think I found influential the WRLG approach that was provided yesterday in terms of it's a waiver from CPW that is confirmed by an exception from the director, which then is ultimately decided upon by us. And our decision is going to be based upon 181. Is it protective of wildlife? And I have come to the conclusion that perhaps that's an easier way to go. And Commissioner Najapa, this is for the between 300 and 500. So it takes you at the 500 as the given, but it grants a waiver, exception, confirmation by commission, 3-step process for anything between the two. It does weave in the 411. And I think it becomes easier than us trying to either exclude 1 and 3 or provide in the statement and basis a understanding of how we're going to do 1 and 3 with regard to these sorts of things. And it's just as to the aquatics. It's not as to the rest of the things under 1202C, the other critters, et cetera. I think that for the others, we just leave it as a variance and, go for it if you think you can prove it or not. So that's where I land on that, at least my initial landing spot. I've reserved the right to move it after I listen to my fellow commissioners. Commissioner Gonzalez and Commissioner Najapa, I appreciate both of you speaking to the Chiropolis landscape planning. The one little caveat there is, Commissioner Gonzalez, the comprehensive drilling plan that has already been approved, we have 2 of them out there. At least the Noble one has some perspective on site planning, but it certainly was not done under the prism of 181 wildlife protection that we're debating now. And so I get a little concerned that maybe it's for future caps and that we look at the 181 CDP that was already approved on a case-by-case basis. So I just sort of put that little nudge out there on that. I'll leave it at that. Commissioner McGowan, you had raised your hand to perhaps weigh in.
Thank you, Mr. Chair. Would you be supportive of Commissioner Gonzalez's suggestion that while the variance process stays the same, in guidance, we would have some language around kind of what we've been contemplating for subparts 1 and 3 in the 502C3 series? Sorry, that's all these numbers. So I think Commissioner Gonzalez was in the same lines that the variance is the variance for everything, and these are the rules. but we understand when we're talking about habitat, that 1 and 3, we've had a lot of conversation about how those apply exactly to habitat, and that there might be a slightly different lens when it comes to the commission. I'm wondering how you feel about that piece that Commissioner Gonzalez put out there.
Well, I was sort of suggesting that we not do the full-on variance, whether it's including 1 or 3, for the 300 to 500 aquatic pieces, and instead rely upon CPW for a waiver consideration, followed by an exception consideration from the director, and then followed by, we would look at it when we look at the whole kit and caboodle under the OGDP. So that's a 3-pronged thing, and it really basically is not, it's not an undue hardship, it's not a anything, it really is just, do we as a commission find this to be protective of wildlife, even if it's within 301 to 500. So I was taking the WRLG approach on that, as opposed to for the aquatic using variance. And then my thought was that the variance would deal with all the rest of the critters under 1202C.
Thank you, Mr. Chair. So I get, yes, I agree with that. I think that the WRLG language is simple, and sometimes simple is elegant, and I am appreciative of it. So I guess what I'm asking, if I'm understanding correctly, I think Commissioner Gonzalez is on the same page, if I'm understanding his 8-point plan correctly. And not having heard from Commissioner Mesner yet, so I guess what I'm asking is, we're treating aquatic with the waiver and exception experience, potentially, from the Western and rural local governments, the language that they put together. The terrestrial species would go through the variance process. And I believe that Commissioner Gonzalez put forth that in the guidance, we would recognize that for variances related to the terrestrial species in the 1200 series, that we recognize that 1 and 3 might be applied a little bit differently or looked at through a different lens. And I was wondering if you were supportive of that.
I am.
Okay, sorry.
I'm interested to see what that SBP language looks like.
Yes.
Like, you know, how are we defining it? Because I had earlier on just wanted to exempt out those 2.
Yes.
And if we're not exempting them out, I would like to know how it is we're further defining that you can't do it and it's not an undue influence.
Okay, so, Mr. Chair.
Undue hardship.
Yep.
Yes.
So related to point 8 of the 8-point Gonzalez plan, the Kinder Morgan language, and then layering on, I think, Commissioner Nanjapa, I think what you're saying is, if an operator takes advantage of that language, the 411 rules automatically apply, would this apply to only terrestrial, or does this apply to also aquatics when BLM is involved?
Commissioner Gonzalez, I think that's a question to you.
I'm sorry, can you repeat that? I was scanning over to my other notes over here.
I see how it is. So when the 8th point of your plan to use the Kinder Morgan language, and then Commissioner Nanjapa's suggestion, if you take that path, the 411 intermediate buffer rules would apply. Are we applying that when BLM is involved to all species or just terrestrial?
I think that was made for all species, not just terrestrial, because BLM is going to have an opinion on everything. I mean, the whole swath of what the OGDP encompasses.
Okay, thanks. I think I need to hear some more from folks, but thank you.
Mr. Chair, could I clarify? Thank you, Commissioner McGowan. I think just to clarify that for that particular piece that was suggested by Kinder Morgan, I wasn't directly tying that to the 411. That was more related to the aquatic habitats, that anytime you're within 1,000 feet of the aquatic habitats that we designate, that was the wildlife hunting and angling proposition. But that's separate from what Kinder Morgan was suggesting, which I think would apply in any scenario of the consultation with BLM, where CPW would be involved in that process. And what they're requesting is that there would be the opportunity for the waiver in that situation. So
okay, my apologies. I thought you were applying 411 to 1,000 feet plus the the
No,
Kinder Morgan
sorry, I
language.
apologize for that confusion.
Commissioner Gonzalez.
Yeah, thank you for that. And thank you for the clarification, Commissioner Nanjapa. Yes, with the 411, I think that only applies to water supplies because it applied, we're kind of taking the analogy from the public water intake rules. And so that's for the 411 application, yes, just to aquatics, but for the general BLM waiver, kind of to all of 1202.
Commissioner McGowan.
All right, I know Commissioner Messner still hasn't had a chance to speak. Clarification to Commissioner Najapa. 411 out to 1,000 feet for the gold medal and cutthroat, or all aquatic species?
Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Commissioner McGowan. I like the idea that whatever aquatic habitats we designate within the high priority habitats, I was proposing that we put gold medal waters within cutthroat so that would become now part of Q instead of S, I think, or whatever. Yeah, I think what the sport fish. Anyway, but I was suggesting that anytime that any proposed location is going to be 1,000 feet from those particular designated streams, that we apply the 411 A2B scenarios.
So to all aquatic habitats, Commissioner Nanjapa.
Yes.
Commissioner Messner.
Thank you, Mr. Chair. And so I'm going to throw a few thoughts out there. And I appreciate everyone's ideas, because that's what I want to do today, certainly initially, is listen to everyone's ideas and try to absorb those different ideas. And, I certainly have ideas of my own, but I think that, one of the things that I found as I was evaluating this last night is, there's lots of different ways to get to the exact same point in this particular situation. And, I think a lot of the conversations that we're having around waivers versus variances versus hearings versus, adversarial procedures versus evidentiary procedures. I mean, a lot of this is semantics, because I think in application, we get to the same point through either an OGDP hearing or a variance hearing. And it's really developing the body of evidence necessary to, make good informed decisions about protecting wildlife resources. And so that's kind of the lens that I'm looking at this through. And I think some of these debates are semantics. But having said that, these are very, very important conversations and very important things to be working on. And so I'm not trying to minimize any of the conversations that we're having. I did review, all the testimony we received yesterday. I tend to agree with Chair Robbins that there is some value to the proposal that the Western Rural Local Government Group put forward, and in the way that it simplifies the approach, and I think still accomplishes a lot of what we're hearing from a number of different stakeholders. I do want to clarify that as I read the proposal from the Western and Rural Local Governments Association for Rule 1202C, that the CPW may waive the application and the director may grant an exception to rules 1202C1R and S. And so it is specific, that proposal, to RNS, which I think is appropriate. And that it has, double A and double B. Double B is kind of reiterating the proposed waiver and exception process for intermittent and ephemeral streams, while double A kind of specifies more of the perennial streams. I see some value in actually just applying double A to everything, because it does then create a waiver process for both perennial, intermittent, and ephemeral streams. And I know that there's some concern out there that some of the perennial or ephemeral streams may or may not be mapped properly or needs on the ground truthing. I do think that there's, a number of different ways to be able to ground truth those intermittent and ephemeral streams, and should there not be appropriate habitat or the designated wildlife or aquatic species present, that CPW already has the ability to waive that in a previous rule in the 309, in the 300 series. And so I'm not sure the benefit of actually having those two things separate rather than just having the AA, which is a proposed OGDP or Form 2A for a new and existing oil and gas location situated less than 500 feet and more than 300 feet, would be able to have the waiver and exception as long as the intermediate buffer zone 411A2B rule is applied, and we're able to apply the best management practices. And so I do think that that accomplishes some of what we're hoping to accomplish here. And I'm not sure those two things need to be separate. I do not agree with the Western Rural Local Government Association's proposal in Romanet II, which is CPW may waive the application of 1202C1T, which is the state park and wildlife area. And I don't think that's appropriate.
Commissioner Gonzalez, can I ask a question on that point?
You want to ask me
I'm
or
sorry,
Commissioner
no,
Gonzalez?
Commissioner Messner. I was looking at Commissioner Gonzalez and I was asking you, Commissioner Messner. And maybe this is also a question for Director Murphy, but I thought that the Roman numeral 2 was part of our original draft, and I could be totally wrong. And instead, that was not a WRLG move.
And that could be, I might have misinterpreted that one when I read it, but.
May I share the screen?
Please.
Sorry, there's kind of a lot going on my screen right now, but so the language in blue, I understand to be Western Rural Local Government Coalition's recommended change to existing language. So everything in black, aside from the underlining and italicizing and bolding, is existing proposed language. I mean, and that, sorry, that underlining, italicizing, and bolding is emphasis, not changes to staff's language.
And again, Director Murphy, just to put a point on it, but staff and CPW were okay with Romanet number 2.
Correct, we proposed it.
That's what
And I apologize, for that, because I was getting confused as far as what was there and what was not. And I've tried to cross-reference this as much as possible, and I sometimes am successful and sometimes I'm not, clearly.
Commissioner Messner, nobody's as effective as Joel is on that point. So the rest of us will just be humans on it.
Right. Nonetheless, as I read it, my comments stand that I think that BB can be folded into AA should that be a path forward, because I do think that's still, I mean, to me, they're one and the same at that point, where you're still have lots of opportunities to ground truth and create waivers and exceptions should there not be that habitat or species present, which would be in an intermittent and ephemeral stream, as well as, any other species that we're talking about in this. And so I do think that this is specific to RNS. I do think that Q needs to stand separate from this and stand with the rest of the habitats that are included in 1202C, or the rest of the species, I should say. And as to, I acknowledge that, I made comments a couple of days ago about, how I do trust our experts at CPW, and, if they tell me that these are appropriate buffers in order to be able to protect these species. And the way that we protect these species is to avoid these areas, then I agree with our experts. I also think there's a significant amount of information on the record presented during these processes in order to back up those. I acknowledge that CPW indicated a couple of days ago that in some of these incidents that 300 foot is a protective standard. And so that, to me, if that's what they're telling me, then I have to agree with them. And I do think that there's additional information that has been provided on the record from a number of different parties that show that that more than 300 feet is appropriate, which is why I think that 300 to 500 foot, intermediate buffer, I can be okay with that. I'm more comfortable with the 500 foot buffer and the cautionary principle. But if our experts at CPW are telling me that's not necessary, that that an intermediate buffer in that area could be more appropriate, then I can be swayed by that. I will also reiterate my desire to see, a technical work group or a stakeholder process or some additional efforts towards regionalizing some of these in order to really decide whether a blanket statewide buffer is appropriate moving forward here. I think this is certainly a good process we're going through, but I would guess that there's certain parts of the state and certain watersheds, certain stream sections that probably need more buffers. There may be some that need less buffers depending on more site-specific information. And so I continue to be in support of that. My cell phone is ringing downstairs, and so I'm not going to run down and get it. And then as to the variance process itself, and so I have also given this quite a bit of thought. And, I think the variance process, by some has been characterized as adversarial. I look at it as a hearing process, more evidentiary based in order to be able to develop the information and the record necessary to make good decisions on variances to our rules. I think that the waiver process also goes through a hearing process. And so, I have some comfort in that, but I think that the variance process is still appropriate in these areas where our professionals and our experts at CPW have told me that we need to avoid these in order to protect wildlife. And so I also acknowledge that section 3 in the variance process is something that we added during this rulemaking hearing, which is the undue hardship piece. And perhaps when we added that, we didn't look quite far enough into the crystal ball to determine how that may affect this particular series. And so I actually think that that's potentially one that does not necessarily need to apply in this situation. I do think that one still needs to apply. And I do think that that's an appropriate application in a variance process. I also think that, all of them can certainly be argued and probably successfully argued in a variance process if the evidence is there in order for them to be granted a variance. But I can be swayed on 3 because this is one that we have recently added. So I'll leave it at that for now.
Thank you, Commissioner Messner. I would segue a little bit off of that point. I went back and looked at current Rule 502, and current Rule 502 only had the basically subparagraph 1 and it's not against the intent of the act, and that's it. And so we added quite a bit to the variance rule, and I think it's important for everyone to understand that as drafted, our variance rule is threefold harder, I guess I would say. And so we need to be aware of that. And so for me, I think it is important. Well, number one, that's one of the reasons that I'm in favor of the WRLG approach, which is still waiver from CPW, exception from director, and then we agreeing to all of that. It's a threefold process to ensure protection of wildlife. If we're using the variance for the rest of the critters under 1202, I would just agree that I don't think subpart 3 does make sense in that instance. And then I guess I would probably, with regard to your approach of combining AA and BB all into AA, the only thing that I'm wondering about is BB was specifically drafted by CPW and our staff to have a full-on out where it's still protective of wildlife resources for ephemeral and intermittent. And if we collapse it into AA, then we lose that for the less than 300 pieces, because AA is only granting the waiver and exception between 301 and 500. And I'd like staff to maybe weigh in on that. Because I don't want to lose something that staff had suggested, because I rely on staff for the concept that interim and ephemeral, which is a very large swath of streams, if it can be protective, that we could get a full-on variance or a waiver there.
And just, Mr. Chair, just to clarify what my thought process was on that, I acknowledge that. My thought process is that the ability for CPW to waive based on no suitable habitat or no species present would still allow for that full waiver inside of 300 feet.
Commissioner Nunn-Johnson.
Thank you for those thoughts, Commissioner Messner, and for this discussion. I think, so I have I guess a question, and I don't want to preclude staff from weighing in on what was just, asked with respect to the intermittent and ephemeral, but we do have that other provision that is, if the habitat or the species is not present, which is the 309E3C, and I believe Mr. Dronlo said that would apply to 1202C, any of the 1202C species, and any of the 1202D species. And so, the circumstances under which the ephemeral and intermittent, that most were raised were that the stream habitat is not there, or that it's degraded enough that it's not, viable for the species. So I was just curious, from the staff's perspective, how those two interact, but also, just thinking through this, that because we have these other provisions that allow for these waivers in those circumstances, where I came around to the variance only, and with the idea that, within 3 to 5 in a variance context, that those additional provisions that Commissioner McGowan had brought forward yesterday from 411 would apply. It is thinking about this in that we have outs already. And so in these situations, this would be when the habitat is good. And so then they're asking for an exception when the habitat is good. And that's where I kind of took a little bit of it made me kind of rethink all of this, because this is really important habitat area. And so if it is present and, good quality, the species, the stream, is running, then, as, we've talked about a lot, there's not a lot of good ways to mitigate. There's not a lot of ways to really restore very well. And I would, encourage in any of those situations that we would grant a variance, the use of existing well pads, which came up. But anyway, I just wanted to kind of bring that forward and get some discussion from the other commissioners that, what we're talking about with these waivers and et cetera, whether a variance or a waiver is in the instance that none of those other situations apply. So therefore, this is, otherwise untouched habitat.
Director Murphy.
I think that there is kind of a question embedded in there, and maybe I'll just start with what I think of as 309E3C, which is the stream isn't there, right? Or the habitat is gone, or the species are gone in a fairly permanent way, which would be distinguishable from an intermittent or ephemeral stream that only flows part of the year. You could certainly have a mapped ephemeral intermittent stream that isn't actually there and would qualify under 309E3C. So I think that's one component of it. And then to me, the question kind of on the table is I've heard a fair amount of support for the Western Rural Local Government Proposal AA to help build out a 300-foot NSO for the most part, and then an intermediate buffer with BMPs in the 300 to 500 foot space for all RNS species or RNS habitats. There is, to me, like kind of an open question from commissioners whether BB should continue to be in the rules. To answer Chair Robbins' question, yes, staff proposed that to apply to from 0 to 500 feet, recognizing, however, that as you get closer to an intermittent water body, concern about impacts to it would probably increase depending. I mean, I don't want to speak too much for our wildlife colleagues, but I hope I kind of touched on answers to the different questions or components, and I'm happy to take it again if I did not.
Commissioner Najapa.
Thank you. I think that helps. I guess, you know, and I think I understand what you're saying, that there may be some instance where there is habitat there, and there may be a situation where the development could occur in a way that could be protective. Within that, the BB, what we're referring to as the BB, but, you know, we also talked about kind of where the alternate location analysis comes into play. So, you know, all of these habitats would be required to go through ALA. And so, so then they're coming to us with, you know, having looked at all the other areas that they might be able to develop, and are proposing this particular area, which, you know, if CPW saw that there was not habitat, I would think that then they would be able to use or exercise the 309E3C, or if there was, you know, some other reason under 309E5, you know, with the intermittent and ephemeral waiver, they could recommend that, I guess. So yeah, so I'm just trying to understand. So, I mean, is it correct? Am I correct in understanding that when we're talking about these situations, it's when none of those scenarios apply? And so, in other words, it's you know, within 500 feet of these aquatic habitats, and it is not that the habitat is not present. It is not that there can be other protective measures. So that's where I want to make sure I'm correct in understanding that those proposals would only be coming to us in those situations.
So for example, like if we're running through how we're analyzing a location, yes, we start with the ALA, and none of the conversations that the commissioners have had so far would change or modify the requirement to conduct an alternative location analysis if you're in high priority habitat period, whether it's 1202C, D, whatever, right? Recognizing that there is the opportunity for CPW to waive an ALA. But I'll put that aside, right? The ALA helps inform why a location was chosen in comparison to others around it. I think step 2 is correct in what you've identified, Commissioner Najapa, is do the on-site conditions comport with what the map reflects? And so if the answer is no, CPW staff will make the appropriate decision. And I think that's where Commissioner Gonzalez's suggestion to include guidance or clarification in the statement, a basis and purpose about how 309E3C works is really appropriate, right? And so then if the map matches what's on the ground and we're in an aquatic habitat at 300 feet, 500 feet, then we'll have to work through the different challenges or opportunities, right? However you look at those rule provisions around siting within it. If it stays with what Western Rural Local Governments has proposed, if you're between 300 and 500 feet of an aquatic native or sport fish waters, the site could be approved subject to the BMPs and any additional BMPs recommended, right? If it's proposed within 300 feet of an intermittent ephemeral aquatic native or sport fish, BMP, it could be waived by CPW under staff and the Western Rural Local Government proposal with appropriate wildlife protections recommended. If a site was proposed within 300 feet of a perennial aquatic native or sport fish, it would require variance, is how I read the rule kind of as proposed. Does that help work through it?
Commissioner Nanjapa.
Yeah, thank you. So I mean, yes, it does, but I guess what I'm getting at is, like, apart from the WRLG proposal, we can, the way we have it set up in the current draft as is that, you know, within 500 feet, anybody can apply for a variance. We still could put those conditions of approval of the 411A2B in a variance scenario. And we have these other waiver provisions for scenarios when the habitat species are not there. And what we're talking about then is this situation, you know, again, whatever it is between the 300 and 500 that we're, you know, contemplating their variance or waiver, what I'm getting at is that what we're talking about is an area that has, it's been evaluated for those other things, you know, with the CPW consultation, and it still is a good, the habitat is present, the species are present. And so that's where we're looking for the waiver. And so this is, okay, so then I just want to make sure that that was correct. Is that?
I think so, yes. I mean, to me, it feels like embedded in your question is what's the right process, right? Or
yeah, I mean, that's where I'm getting at, but I just want to make sure that I was understanding that if you're even considering whether variance or waiver in these proposals, CPW is already doing consultation because it's high priority habitat. There has to be an ALA, so they've already gone through all of that. And what we're now looking at is a scenario where the other waivers for intermittent ephemeral or the habitat's not present don't apply. And so now we're in a situation where there is habitat present, the stream is flowing, it is, you know, whatever, there's those other situations aren't there. And so that's what we're contemplating. Is that correct?
I continue to think that my answer is yes. I get confused with this and that's in the question itself. Like, and maybe it's easier to, I mean, have a process flow almost, but fundamentally, like, yes, the ALA has been performed. Yes, there's a confirmation that the habitat or species continue to be appropriate for the level of protection set out in the rules. And so then the decision point is how and who can waive, right? Whether it's CPW, staff, commission.
Sorry, just a quick follow-up. And then we also have the provision that there's a pre-consultation opportunity for a variance as well, where they could have CPW take a look at what they're proposing for a variance ahead of time, and that could be provided in a recommendation with a variance. So that doesn't preclude them from getting that answered by CPW. I just, you know, I'm just trying to make sure that we've got all of these bits in place, and that, so what we're really contemplating when we're talking about the WRLG proposal and what other stakeholders have mentioned is in the scenario that all of those other things to not apply. Those other waiver options are not being exercised because the habitat is there or the species is there, et cetera. And so, yeah, okay. So that's all I wanted to get at, and I'll stop for now. But I am kind of getting at this in terms of, whether or not a variance or a waiver is the appropriate thing.
Commissioner Messmer.
Thank you, Mr. Chair, and thank you, Commissioner Nanjapa, for continuing to dig down on that one. I think the question that I have, though, is that in BB on the ephemeral and intermittent streams and the waiver process there, is that as drafted, there is no variance process there. The waiver is able to be provided, and the exception may be approved irregardless of how far it is away from the ephemeral or intermittent stream. So there's no hard 300-foot NSO like there would be on a perennial stream. And so this is why I'm suggesting that BB gets folded into AA, so it does have that basis for protection. And there is still the ability to waive all the way down to 0 if they're in, the 309 C5 or whatever it is, based on the lack of habitat or species present. And so there is the ability to waive down to 0 based on that criteria, but that it still has the baseline of protection that the perennial streams have at the 300-foot NSO, with the ability for 300 to 500 feet, with the best management practices and the 411 protections in place. If the species is present and there is appropriate habitat, it's flowing or whatever that situation would be on the ground. And so that's my rationale for folding that into AA, because I do think that creates a baseline of protection that should be necessary and reasonable in to protect these particular habitats and these particular species.
Commissioner Nanjapa.
Just to follow up on that, and I totally agree with that. I think I'm also proposing a 300-foot NSO that I think would, we would want to accept, or I would prefer to see that accepted from the variance process as well, because we already have these other off-ramps when habitat species are not present. So that's what I'm saying there. But I totally agree that I think that we should have a harder NSO buffer around all of these aquatic habitats, because they are so sensitive and are so difficult to restore if there is disturbance.
I appreciate both of your perspectives, but I'm not sure that I agree, given that this is what CPW told us they wanted to see in the rule from the beginning, is this ability to have an intermittent and ephemeral stream out, given the vastness of the lands that are covered by that. So I guess I'd like to hear from CPW about removing something that they actually advocated for, and that a lot of other of our stakeholders have expressed that this was a good thing. So that's just one commissioner talking, but Commissioner Messmer.
No, I would appreciate hearing from CPW as well, although I will acknowledge that there's a number of things that CPW has put into the rules that we're debating right now, including having variances for almost everything as drafted, and that we're debating those at this point. And so it's not like it's out of line that we're potentially looking at a modification here.
Commissioner McGowan. Thank you, Commissioner Messmer. I think I saw your hand.
Yeah, thank you, Mr. Chair. I agree with Commissioner Messner that we are monkeying around with the original rule proposals, but I would be curious to know why BB was put in the way that it was originally, and just get some feedback from CPW.
Director Murphy, could you bring Mr. Holst or Mr. Ackerman or some of the other fine folks from CPW into the House?
Sure. And while we do, I just, in terms of timing, when staff proposed the 300-foot setback for all of the aquatic layers, we did not include the off-ramp for aquatic ephemeral aquatic, ephemeral, and intermittent, and then brought that in as part of the package with the 500-foot recommendation and in response to party comments. So with that, hopefully we've got Team CPW here also.
I see that they are making their way into the house, so let's give them appropriate time to unmute and visualize themselves if they so care. Good morning, Mr. Holtz.
Morning, Mr. Chairman, commissioners.
Have you been listening to our debate?
We have. It's been a little hard to follow, but we have been listening. Yes, I think it is correct that, I mean, we did add that waiver for intermittent and ephemeral specifically. I mean, it was not in our original proposal. We did add that specifically to try and address some of the concerns in the original party statements from stakeholders on, you know, basically the difficulty of managing around those aquatic buffers. And so that's why that was added. You know, I don't think we would oppose a, you know, I guess a hard sort of floor on what the buffer, you know, requirement should be for those. At the same time, you know, we could manage that intermittent and ephemeral with a sort of site-specific look. You know, it would be, you know, it would, you know, probably be a little more staff time intensive to do it site specifically than if we had a hard floor. I mean, we do agree that the 309E3C language does allow us to, you know, if the habitat is not there and the species is not there and it's not likely to be there, yeah, that would allow us to basically go to 0 on that buffer and basically take that off the map, which I think was the original concern, is that some of these things might be mapped inappropriately. And so I guess I do agree with Commissioner Njapa that that really does handle that situation. And so I guess in summary, you know, I think we're, you know, more or less comfortable either that we could make it work either way. We could make it work with the 300-foot floor where the habitat and species are there. We could also make it work for the intermittent and ephemeral for native fish and sport fish, you know, if that floor wasn't there. And so the last thing I'll add is, I mean, in terms of sort of how we prioritize, you know, these buffers associated with these species, I mean, just so the commission knows, we do, you know, native fish are really important. And so for us, you know, native fish are sort of right up there with gold medal waters and cutthroat waters. The sport fish is an area where I think maybe we have more room to compromise, at least from a CPW perspective.
Thank you, Mr. Holtz. Mr. Ackerman, Director Murphy, do either of you desire to weigh in on the issue?
Thank you, Mr. Chair. Again, Brett Ackerman, Southeast Regional Manager, Colorado Parks and Wildlife. And no, I don't have anything to add to what Mr. Holtz said. He represented us well as usual.
Director Murphy? We can't hear you, Director Murphy.
Thanks. I've got like all of the different mutes and unmutes working, which is not very efficient when I'm trying to talk, as it turns out. So I think that I've heard the idea of kind of an variances could not apply within 300 feet concept filter through a couple of different comments over the course of the last few days. And I would strongly recommend that we create an NSO, but that we also don't eliminate the tool of a variance. We don't know what situations may come about. And I think that this commission can look very hard at a variance question within that 300 feet or whatever the NSO ends up being. But there are a reason that almost all codes and standards include variances, and that's to allow for, when you look at a proposal in total, looking at it one way versus the other, or having a bit of flexibility, recognizing that it would continue to achieve 181's objectives is important. So I think that that's something that I haven't addressed very directly over the course of the last few days, and wanted to offer my thoughts on it at least.
Thank you, Director Murphy, for that. Mr. Holtz, I had a follow-up question on the ephemeral and intermittent. If it were to remain as is with BB and having this sort of waiver, which I would remind commissioners is also then approved by director as an exception, and then approved by us as commission. So I don't want to miss out the fact that it's still a 3-part approval process. But if we were to do that and leave the ephemeral and intermittent out there, does CPW still has the ability, using timing stipulations, et cetera, to ensure protections, even if it were to be closer? Is that still a tool in your toolbox?
That is still a tool, yeah. I mean, as far as the construction activities themselves, certainly, and we envisioned that similarly for the provision for essentially crossing those aquatic buffers with either for access or utility construction. I mean, we would look very closely at those proposals and try and make sure that the operator was timing those operations to avoid spawning dates and things like that. So yeah, timing is certainly something that we would use in addition to any buffer.
Thank you. And thank you guys for your continued work with us on this. This is a very important topic, and it's good to try to get it right. Commissioner McGowan.
Thank you, Mr. Chair. I was just hoping while we had Mr. Ackerman and Mr. Holst on the phone, on the Zoom, that we could also, I would like to know how often, this is related to the request for a variance, a request for a waiver process on BLM land, federal lands. How often there are situations where CPW and the BLM can't come to an agreement and it is adversarial. I keep hearing this adversarial, maybe that's not the language that's been used. I think it's been adversarial, or it feels like it's in conflict. I'm just wondering how often we get to that point where we just can't come to an agreement with BLM on where to site something.
Mr. Holtz.
Thank you, Mr. Chairman. Commissioner McGowan, it is a great question. So keep in mind that under the previous rule set, there was the provision where we needed landowner consent for any condition of approval for anything wildlife related. So when you think about how that plays out in the context of a BLM onsite, they are the landowner. And so even if we didn't agree with what was happening there related to the wildlife resource, we really didn't have an avenue because we needed landowner consent to actually even put a condition of approval on a permit. And so the perspective that I'll give you is, we have tried, I think I mentioned in my opening statement that, in 2010, we started pushing our high priority habitat recommendations out to other agencies, including the BLM, and try to get them to incorporate those recommendations into lease sales for every quarterly lease sale, into resource management plan revisions, and basically every planning process possible, so that when it comes to the on-site, they actually have those provisions in their NEPA documents. Having said that, we have not been universally successful. And so there are cases where our recommendations dovetail quite nicely with BLM, and there are cases where they don't. And so we will be in a situation, and I think Kinder Morgan's attorney, stated this to a certain degree correctly. We will be in situations where we do not agree with the BLM's assessment and what they decided to include, either through their public NEPA process, or a lot of times it's, if it's a Cat X or something, it's maybe not a public process. So we will be in a position on occasion on federal lands where they are not incorporating our high priority habitat recommendations, and we would like to make those recommendations to the commission. And so in terms of that Kinder Morgan suite of exceptions, I think that's just something to be aware of. And if it's, I guess our preference to a degree would be that we have the ability to bring that forward either way. But it certainly, it's obviously up to this commission on how to do that. But it would be, we will be in that position where we're we're, occasionally in conflict with what BLM has in their sort of toolbox.
Commissioner McGowan.
Thank you, Mr. Chair. So I think I need someone to run through with me then if we head down the Kinder Morgan proposed language that Commissioner Gonzalez put on the table, if CPW and BLM cannot agree and we have this waiver process in place, what does that process look like? That's not, sorry, it's not clear to me now then what happens.
Director Murphy.
Thank you. Ms. Stafford, could you share the Kinder Morgan language so that we can all have the benefit of reading it? I think sharing their preferred option.
Yes.
I'd also like to see their alternate option as well, please.
If I may, Chair, this is the preferred option that I'm showing at the top of the screen right now.
So with this language, sorry, Mr. Chair.
Yeah, please.
With this language, if CPW doesn't agree, it wouldn't move forward under this process, correct? Because this scenario contemplates that there's alignment with CPW and the BLM. I think I'm getting muddled because I think there was, I feel like the concern to get this language was around when there's conflict between CPW and BLM and wanting it to not be adversarial, but maybe I'm sorry. And, but this language, I think if there is still disagreement, CPW, this wouldn't move forward then, correct? If CPW did not feel comfortable with what was happening on federal lands.
Director Murphy.
Thank you. And Commissioner Gonzalez, if you want to interject first, happy to.
Mr. Chair.
Yeah, please.
Yeah, sure. I will let Director Murphy speak to the content of Ms. McGowan's statement. I think that the adversarial nature that's been described is tied to the variance process itself as a procedural process and not necessarily an adversarial relationship between BLM and COGCC. I think the conflict is just in conflict of the substance of those permits when they do come to a variance process. That being said, I read the may in that first line as being CPW may waive as being influential to how I read the language in the Kinder Morgan proposed language. Director Murphy.
Thank you, Commissioner Gonzalez. You actually summarized the first piece I wanted to touch on as well. And I think structurally what's challenging for me about this language is that CPW has provided to us its recommendations that these areas be avoided. That's why they're in 1202C in particular. And so it puts us in the position, or CPW in the position, consulting each time to, again, almost readdress why they were proposed as 1202C lands in the first place. When instead, to me, the framework that is better and more appropriate for resolving the question of whether development should or shouldn't go forward in that location, if BLM supports it, is by folding in the BLM or the important federal documents that are being prepared, including the environmental analysis, which reflects a great deal of work as well, and then letting this commission decide what the appropriate outcome should be, recognizing that CPW has recommended we shouldn't be here, BLM is proposing we should be here, and I'm assuming conflict. As I think Mr. Hull said, most of these issues don't result in conflict, right? But in the event of conflict, to me, it is this commission that should be deciding what, as a policy matter, is the appropriate outcome, and not requiring CPW to go back and look time and time again at an individual location. So that's why staff has proposed it as relying on the important considerations built into the 300 series to also encompass wildlife-specific BLM concerns. And I also acknowledge that Kinder Morgan in particular and most of industry disagree with my approach on that. So,
but Director Murphy, doesn't that get at and Ms. Stafford, if you could flip to the next page, I mean, doesn't that get at their alternate proposal, which does require us as commission making the decision-making body to consider the recommendations of CPW as well as the federal land management. And so while I know that that's not their preferred, I tend to think that's the preferred position from my perspective as a commissioner, is that ultimately we're making that decision based upon both sets of information and data. That's not really a question, I guess. Commissioner Messner was first, then Nanjapa, then Gonzalez.
Thank you, Mr. Chair. I actually tend to agree with you there, that in any variance process, there's going to be whatever evidence needs to be provided in order to support the position of the variance. And in a federal land management situation, that there has been a decision made and there's been a significant body of evidence provided in order to make that federal land management decision, that most certainly would be utilized in a variance hearing. And so I'm ambivalent, or it doesn't matter to me whether this language is incorporated in there or not, because I think it's just inherent in the variance process that this information would be provided. So I'm good with this language. If we want to put it in there, I think it's already something that would be done in practice anyway.
Thank you, Commissioner Messner. Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Commissioner Messner. I think, yeah, and I just wanted to say that I appreciate this additional discussion and clarification, because somehow I missed that this was specific to 1202C and our high priority habitat. And I was thinking of it more in terms of, other scenarios when BLM's recommendations would conflict with ours. And so I tend to agree, as Director Murphy, explained it, that, we've already got a recommendation from CPW with high priority habitat. And so we already know that those are areas that we want to avoid. And even with the waiver containing conditions of approval, then that's really, again, going back into our variance process. So I'm withdrawing my original support of this particular measure, because I agree it's not necessary, given what we're trying to do, and understanding that there will be these conflicts, but that CPW has the ultimate authority over the wildlife management on these lands.
Commissioner Gonzalez.
Thank you, Mr. Chair. And I have some questions for our attorneys on this. My first question is, are there any limitations on what evidence can be presented at a variance hearing? Or can the parties just bring whatever they want?
I see lots of attorneys materializing. Who would like to take that first?
Mr. Chair, I'm happy to take that first.
H.E. Davenport.
Thank you. So a hearing in front of the commission is generally an evidentiary hearing that would follow standard evidentiary rules of relevance or things like that. I think all the things we've been considering in a variance hearing would probably be relevant. And I also want to point out that this commission has relaxed evidentiary rules pursuant to the APA and pursuant to its own rules over what it could hear at hearing. Ultimately, the decision would be yours about what you want to hear at a hearing. And so if you thought that something was relevant to your consideration, it was something that you wanted to hear about, you would hear it at that hearing. There are certainly elements right now in 502C about that may guide what would be relevant at a particular hearing on a variance. And again, a variance will always be considered in the context of the rule that the variance is requested from. But ultimately, as I said, if you thought it was relevant and you wanted to hear about it, you could hear about it.
So no, kind of hearsay limitations with a party bringing in saying, hey, here's what I talked to BLM about, here's what they're good with. And, I'm just thinking about this in terms of kind of a more courtroom setting, but I would imagine if there's an opposing party, they may argue, hey, BLM's not here to tell you that's the truth.
That's accurate in the sense, thank you, Mr. Chair. That's accurate in the sense that you could certainly have a party say, hey, that's not relevant, or that's hearsay, or whatever. Again, this commission does not have to adhere, is not required to adhere to the rules of evidence as they would apply in a state court or federal court of law. You could hear information even though it may be under those strict rules of evidence. A hearsay objection would be upheld.
Okay. And then I guess this is going to be kind of a weird question that maybe you may not be able to answer, but in your experience, how long does a variance hearing last in front of the commission?
Thank you, Commissioner Gonzalez. It's hard to answer that question because under the current rules, most variances are director granted and simply reported to the commission in the staff report. So I am not immediately recalling a variance hearing in front of the commission that was actually a full evidentiary variance hearing. My recollection is not perfect, and so there may be, the director, for example, may be able to come up with an example, but so it's hard for me to answer that question. I think in general, the more complicated, the longer it would take, the more parties, the longer it would take. But, you know, and then we're also talking about two kind of lengths of time. We're talking about the actual time in hearing, number of hours or number of days. But I think your question may be more how from the application for a variance to the ultimate commission decision on that variance, how many days or weeks or months is that? And again, I'm sorry, I can't really give you an exact answer because we've never had a full-time commission before. And so my guess is that if it was a situation where there was some urgency, that things could proceed pretty quickly, given that we have rules that require notice for a certain number of days and publication and that kind of thing for applications.
Yeah, I appreciate that, Mr. Davenport. And I'll tell, and what I was getting at with that was, you know, I'm kind of concerned about hearing a new situation that's being requested for a variance without having, you know, the full experience of the coordinated efforts that lead up to that. You know, those ongoing conversations that happen with BLM and the operator, that happen with CPW and the operator, that happen on site where there's, you know, eyes on and what that really looks like versus, you know, what you're hearing on paper and kind of, you know, prose descriptions on what has happened and what is going to happen and what it looks like, and just being limited to, you know, to an evidentiary record in that regard. But it sounds to me like this is one of those cases we're going to build that ship as we sail it. And so, you know, that's my concern. I don't know if that concern is valid or if you care to address it, Mr. Davenport. And then I've got another question after that.
Mr. Chair.
Mr. Davenport.
Thank you. Well, first of all, commissioners, you're largely in control over what you hear and what you think is important and want to hear about. So, Commissioner Gonzalez, first of all, I think variances can arise in a variety of different situations. I mean, you could have a one-off variance that's not associated with really any other application. You could also have a variance in the context of what we've been discussing where it's part of an OGDP application, in which case it most likely wouldn't come before you until you had a director recommendation on the entire package, in which case your record would contain probably quite a bit of information about the back and forth and what discussions were had and recommendations from folks about what they think should happen in regard to a particular variance. At least I know that's what's being contemplated. Ultimately, even if it got to a hearing before you and you said, you know what, we don't have enough information on this piece, it is always within your ability to tell the parties, go back and get us this information. We can't make a decision without this information.
Thank you, Mr. Davenport. One more question is, there was the issue of preemption brought up. And I don't know that I'm an expert in that. I mean, I do know that I'm not an expert in that. I'll start there. But I don't know enough about that to give that the consideration that's been requested of us. So could you explain what happens if we deny a permit on federal lands that the feds otherwise approve?
AG Davenport.
Mr. Chair, thank you. I would like to defer to AAG Minor, if it's okay with him, to provide an answer there. I think he's probably better situated to answer that question first, and then if I feel like I need to chime in, which I feel like is doubtful, I will.
AG Minor.
Thank you, Mr. Chair and Mr. Davenport. The question of preemption is, I do want to acknowledge, a somewhat open legal question insofar as that specific scenario under Colorado law hasn't necessarily arisen in the courts before. But the general legal framework that would apply here is based on the U.S. Supreme Court's decision in a case called Granite Rock versus California Coastal Commission. And in that case, the courts would look to whether the basis for a state choosing to preclude some sort of use of land that was authorized by the federal government is rooted in an environmental consideration, or if it is rooted in sort of land use planning. If it was rooted in land use planning, the state permitting decision could potentially be preempted, but as is the case here with environmental, or in this case, a subset of environmental considerations, wildlife, it is unlikely a court would consider that state permitting decision to be preempted by federal law. There's pretty broad recognition by the US Supreme Court and in numerous federal courts, as well as state courts applying that decision, that when states are regulating for the purpose of environmental protection and wildlife would fall within that a state permitting decision would not be preempted. And I'll actually note that the preemption case law has often come up in wildlife management decisions that are unrelated to permits. So just general wildlife management decisions in federal courts, including the 10th Circuit Court of Appeals, which has jurisdiction over Colorado, have recognized quite broad state authority over wildlife regulations. And in fact, I'm not aware of case law in the 10th Circuit finding that a state decision to either protect wildlife more or protect wildlife less, which is usually when this comes up, finding that that's preempted by federal law. So I would say that under the federal preemption law, state authority to issue permissible environmental regulations is at its zenith when those regulations are targeted at the protection of wildlife.
Thank you, AAG Minor and AAG Davenport.
Commissioner Nanjapa.
Thank you, Mr. Chair. I had a question just in this instance that, in thinking about this Kinder Morgan language, and given what I just realized that this is, we're talking about specifically within high priority habitat, there is already a requirement for consultation with CPW in high priority habitat. So I was curious if maybe Mr. Holtz or Mr. Ackerman could comment on kind of how, that, well, I guess this is relatively new in the rules, right? This hasn't existed before, but there is typically always consultation in that earlier part of the decision making. Is that correct? And so therefore, if there's a real problem with a location, you can give them that understanding early on, because I think that was the crux of the concern, as I understood it.
Commissioner or Mr. Holtz.
Thank you, Mr. Chairman. Commissioner Nanjapa. Yeah, that's exactly the case. I mean, if they do go through a NEPA process in particular, we participate in scoping. We are on their sort of interested party list. So if they're doing it sort of under the NEPA umbrella of a different NEPA document and they're actually just doing an APD notice of staking, they'll invite us to the on-site typically, and we do go and we express, and we know pretty much right away if there's going to be a potential conflict with what they have in their RMP, whether or not they adopted those high priority habitat recommendations that we had sent them during the RMP revision process, whether or not they put it on the lease as we recommended it during the lease sale. And so we will know I think pretty early on if there's a potential for a conflict. And we do try and work those out. I mean, I don't want to paint it as though it's always a conflict. I mean, oftentimes that things dovetail quite nicely, and we get to where we need to be. But there is, a potential that we're not going to match with what BLM has in their RMP or in their NEPA that supports that particular action.
Thank you, Mr. Holton. So I guess in that instance, that's was part of the question I was asking Kinder Morgan, is that, so that way, especially if CPW says this is not a good location, then they can continue, or they can move along to a different location, or look at other options, and work with BLM on a new location. So I think, yeah, I mean, I guess these are those instances that already occur where you're already consulting, you're already telling them there's a go or no go, and we're just kind of clarifying that in what we have in our rules already with the high priority habitat, requiring the consultation. Okay, thank you. I think I'm good.
Commissioner McGowan.
Thank you, Mr. Chair. I think I'm less confused now, so appreciate everybody's reminders of the conversation yesterday. And I do think I'm still trying to figure out how we recognize in our process when a variance does not have an issue and there is not conflict, that there's some sort of process or identification for the commission to identify that this is a variance that has support from our federal partners and from our CPW partners, and it would feel more comforting to an operator to know that that's how it was going to be presented, or that was how it was going to go through our process. I mean, I think that's, correct me if I'm wrong, I think that's kind of the crux of what the operator's worried about, is that, and again, if we are requiring pre-consultation up front, we should not get to a point where they're trying to do something where they go to the BLM first, get it approved, and then come to CPW and find out that it wasn't appropriate. And so are we helping address that by by saying pre-consultation already, and then as it goes through the process and gets to the commission, there's some sort of language or acknowledgement that the parties all work together and there is support from all the parties, so the commission is cognizant that it's a variance process that's been supported. I'm just, sorry. So that's my thought, but I don't know if there's an answer.
Commissioner McGowan, if I
Director
may.
Murphy.
Thank you. I think that's a lot of what staff's job is, to bring forward to you the information about respective parties' positions on issues and whether there's controversy or not. For the most part, if there is controversy, it will be fairly apparent through the filings, I think. But at some point, the director, or whomever my successor is, will have to make a recommendation to you about a particular proposal. And of the factors considered, it will be based on the totality of the circumstances, and what support is in the record or not, or controversy is in the record or not, and would reflect that to you all. So I do think that there's a path. I think that's largely the purpose of the 300 series. I think that the alternate language from Kinder Morgan solidifies that in the context of wildlife specifically. But to me, that is the ultimate function of the director's recommendation. We think you should take X action for these reasons.
And Director Murphy, I thank you. And that's why I'm supportive if there's a need for additional language here of the alternate proposed language. I think it is providing express direction to commission and to our operator stakeholders that are working on federal land, that the commission will consider both CWP's or CPW's input as well as the input from the federal agency, including any final federal stipulations and conditions of approval as we consider a variance. That's my statement. Commissioner Nanjapa?
Thank you, Mr. Chair. Yeah, I agree with that. And I just also wanted to note that, we also have the 309 E5E, which allows for CPW to recommend support of a variance request. So, I just want to, again, just commend the staff, because I feel like all of these things in many ways are already addressed. And anyway, yeah, that's all.
Commissioner Messner?
Thank you, Mr. Chair. And if we want to continue talking about the Kinder Morton proposal or the alternative proposal, I'll hold my question off for a second, but I wanted to jump at some point back to the intermittent and ephemeral streams. And so you let me know when that's appropriate.
Why don't we wrap up on the federal question? And I guess I want to make sure that we're able to move forward as opposed to going around in circles. And I think a lot of this discussion has been really helpful to help educate commissioners in terms of where they may land on some of these issues. But I would like us to kind of start to sequence out. So we need to, maybe we can wrap up on the federal issue and get kind of some direction there, and then circle back on some of the other issues. Maybe we can go back to the Gonzalez 8-point plan and walk through that sequentially so that we can start to get a sense of where we think we might have consensus. Director Murphy, you unmuted yourself and you always lend good ideas to a process-oriented approach. Do you have thoughts?
Yes, I do. Thank you, Chair. Commissioner Gonzalez was gracious enough to send me his 8-point proposal. So I think I could build that into a slide and at least represent to you, or a couple of slides, if I had a little bit of time, and build that into kind of either the options that I've heard about them, or whether I think that I've heard general support for a particular point, and try to identify outstanding questions.
Then let me throw this out there. We're almost at 2 hours of debate. Why don't we take a 10-minute break, give you that chance, or let's do a 15-minute break, give you that chance to do that, Commissioner or Director Murphy, and then we can come back and see if we can get through this component of deliberation before we then take our lunch break. Would that work from folks? Thumbs up? Okay. All right, let's come back at 12:07.
Well, let's see how I did. I'm going to share a screen and then walk folks through. Gratitude again to Commissioner Gonzalez for giving me a foot up on this. And oops, sorry.
I get some more to him.
Thank you.
So he can be tasty.
Sounds like you got some helpers too.
So many helpers. So many helpers. It's lunchtime. Let me try this one more time. And okay. So hopefully everybody can see my screen. I tried to put it in a little bit bigger font in hopes that that helps save all of our eyes just a little bit. And I'm trying to get all of my panel resized so I can see faces. So what I've done is try to chunk this into a couple of different bullet points. The first one being aquatic habitat NSOs, and then a couple of other points. If I put it in green, I thought that there was general consensus, and then flagged it like kind of 2 other buckets of stuff. So I'm just going to walk through the document from top to bottom so people can hear it and digest it. And so what I heard when we talk about aquatic habitats is that there is general consensus for a 500-foot setback or no surface occupancy for gold medal waters. And I'm going to try to leave aside the Q's and R's and S's and T's just because I think it's easier to focus on the actual habitats for precision. As it relates to cutthroat trout, I think I heard commissioners discuss 2 different options, but I didn't necessarily get clarity on what the outcome would be. And so for cutthroat trout, I heard either a 300-foot NSO with an intermediate buffer applying out to 500 feet that would include the 411 A2B 1, 2, 4, and 5 BMPs. The other option that I think I heard on cutthroat trout was a 500-foot NSO sighting within that would require a variance. I think I heard that general support for treating aquatic native species and support fish management waters similarly. Though I recognize they could be broken out if commissioners, and we could have conversations about those individual habitats if appropriate. I think what I heard is that there would be a 500-foot NSO with the generally, but the kind of like, but two different options. One would be essentially what Western rural local governments proposed, which would be between 300 and 500 feet. CPW can waive with director support if mandatory BMPs are applied, and that CPW could waive with director support for locating within 0 to 300 feet of an intermittent ephemeral stream segments. And then implicitly, a variance process would apply for locating between 0 to 300 feet of a perennial stream segment. The other option that I think I heard, is that, again, it would be a 500-foot NSO, but a more limited approach to the waiver, in that CPW can waive with director support for locating within 300 to 500 feet of any stream segment with mandatory BMPs. Citing within 0 to 300 feet would require a variance. The one thing that I have not done is compared the 411 A to B subparts to the Western Rural Local Government mandatory BMPs. I think they line up pretty closely, but I would have to disclose that I think that Commissioner Gonzalez's proposal was very specific to 411 A to B 1, 2, 4, and 5, and so I need to double check that. But so that to me summarizes where I've heard that we are at on the aquatic habitat layer questions. The places where I've heard a lot of consensus, I think, are that we want very clear guidance in the statement of basis and purpose, that the 1200 series buffers, setbacks, NSOs are waived under 309E3 and that subpart C in particular. And that point 1, point 2 is that if 1202C applies and there's no waiver process, the operator needs to pursue a variance, and that staff should include clear guidance in the statement of basis and purpose about how that variance process will be administered in the context of 1202C in particular, and especially subparts 1 and 3 of 502C. I think I heard a lot of consensus that there should be clear guidance explaining the efficiencies of seeking a concurrent variance. And I think that this probably builds out of the flow chart that Greg put together in response to commissioners' requests for Wednesday, or Mr. Duranlo. Another point is that we should have a clear rule mandating CPW consultation as a prerequisite to a variance application. I think that there was general support for that, but I might have misheard. And that the commission would like to consider a waiver process for any pre-sited locations in a CAP, similar to what's in 604B2. The staff would need a little bit of time to put that language together and think through how it fits, just because it's not something we've drafted to date, but I thought that I heard consensus on that point. I think I understood, and I left the Kinder Morgan language in black just because I want to make sure I'm clear and didn't miss part of the conversation. While I don't think I heard like complete consensus about support for option 2, it sounded like more commissioners than not preferred option 2 over option 1. And then I went ahead and put on this list that we need to work through the compensatory mitigation fee. And then I wanted to add a bullet point because I think that there likely are other outstanding issues the commissioners want to address. So that's what I put together to help walk us through where I think decision points are. I think question 1 will be, is there something in green that should be in black from commissioner's perspective? And then my recommendation is just either go through it top to bottom with what's not in green and we can work through it. So that's what I've done.
Excellent. Thank you, Director Murphy. Let me move my screen so that I can see my people. Did anyone want to initially comment on what Director Murphy has presented. Commissioner Nanjapa.
Thank you, Mr. Chair. I think this is looking really good, and I appreciate this approach. One quick just request, can we turn off the paragraph markers? It just makes it a little bit easier to read. Thank you. And then if you could scroll up to the aquatics. You know, one thing that, so I threw out combining gold medal with cutthroat, but we also heard from Mr. Holst that the aquatic native species are really important. And so, and maybe less so with the sport fish management waters. And I think that's especially important coming from him, given that, you know, as has been noted, you know, the sport fish generally that we're talking about are non-native, you know, rainbow and brown trout and et cetera, that are not native species. Cutthroat are native, aquatic native species obviously are native. And then the one difference of the gold medal streams, you know, with respect to sport fishing is those are the best of the best. And so anyway, yeah, I just wanted to make sure we kind of have that out there for discussion as well.
Commissioner Messner.
Thank you, Mr. Chair. And just this is a question for Commissioner Nanjapa, because I thought that you had also thrown out a couple of other items in your proposal that weren't captured here. And I didn't know if you wanted to make sure that those were still on the table for discussion.
Thank you, Commissioner Messner. Yeah, you know, I said I have a preference of a hard NSO, you know, no variance applies up to 300 feet. But I did hear Director Murphy saying that that is not favorable. I appreciate that. And I again, just feel that these are really sensitive habitats that any disturbance is going to be really hard to do anything about. That being said, I also did want to note that I think we all were saying, I think we did have some consensus that anytime there is any variance, waiver, whatever it ends up being less than 500 feet, that we want the 411 A2B provisions to apply. And I would agree with that modification from Commissioner Gonzalez of all but number Romanet 3. But we'll look to the other commissioners to see if we agree on that.
Commissioner McGowan.
Thank you, Mr. Chair. When we say all but, does that mean we'll still contemplate some sort of regular inspection, or are we just taking the regular inspection off the table for under 411 as a best management practice? Understanding that topography or whatever might make it difficult for there to be a daily inspection.
Commissioner Messner.
Thank you for that question, Commissioner McGowan. I mean, in my mind, that doesn't take it off the table. I think that there's a best management practice associated with that, and there's a timing associated with it as far as a, you know, how often that may occur and whether or not daily is appropriate or not. And I think that can be a condition of approval, and, you know, perhaps that can be acknowledged in there as well, or maybe that's just inherent in that best management practice analysis by CPW. And so I do think it's important to not just categorically eliminate it. I will also say that where did the screen go? Have I lost it? Oh, there. So I think that, and I can't remember now because it's not showing screen, but there was, you know, a section in there where we had talked about kind of the utilization of 309E3C and kind of clarity on that. And I do want to emphasize that, at least in my consideration of the WRLG proposal, with the inclusion of intermittent ephemeral streams in there, that would take into consideration that 309E3C evaluation would include determination in that scenario of whether or not there's appropriate habitat or species available, and still allow for the full waiver provision to CPW in those instances where there is no habitat or species, or it's mismapped or for whatever reason there. So it's not a total elimination of a waiver for ephemeral and intermittent streams.
Director Murphy? We can't hear you.
Thank you. You'd think I'd be really good at this by now. I'm not. So Commissioner Mesner, if you look at the option 2 on the screen, the 500-foot NSO with waiver limited to 300 to 500 feet, do I need to add another sub-bullet? Because
Thank you. So let me just read it here quick. So 500-foot NSO with waiver limited to 300 to 500 feet. CPW can waive the director's support for locating within 300 to 500 feet of any stream segment, variance process for locating within 0 to 300 feet of any stream segment. I mean, that's correct, but I don't want it to discount the fact that CPW does have the ability to waive 0 to 300 feet if there is no habitat or species there. You know what I'm saying? That's that 309E3C. And that's inherent. I understand that, but I just don't want it to get misinterpreted as there's not that option available. Does that make sense?
Yeah. Director Murphy, can I ask a clarifying question of 309E3C? Because as I read that, that says consultation will not be required if the operator demonstrates and CPW agrees that the habitat and species is no longer present, or it's become basically a non-wildlife area. And so I read that as you don't have to have consultation, but I don't read that as like somehow or another that's getting around the setback. Or am I just completely off base?
I think that you've touched on the necessity for the clarification, Chair.
Okay.
The way we read that and what it means to us could be clarified. And let me check with the team about it. I can't remember Wednesday what we said on this exactly, but.
Commissioner Gonzalez, did you want to bring perspective here?
Thank you. Two things. So I'll address your point just most recently, Chair Robbins, and I'll work my way backwards. But yeah, I read that into the rule as well, and that's kind of was a point of confusion in the way I read the plain language of the rule and kind of the way we've talked about it. So whether it's in the rule or in the SBP about tying it to the need for a variance or a waiver if 309C applies or 309E3C applies is an impactful bit of language and bit of clarification that's necessary. So so I agree with that, and we'll move on from there. In regard to the 0 to 300 being included as only through a variance process for all stream segments, am I understanding it correctly, Commissioner Messner, that we do not want to account for a waiver for intermittent or ephemeral streams 0 to 300 where CPW has, with the operator and COGCC, determined that the best location is within 300 feet? Not so much that it's just limited to the lack of habitat existing under 309E3C, wherever that is.
So I appreciate the question. I mean, my interpretation of 309E3C is that if the habitat is there and the species is there, then the protections need to be in place for the species that we're indicating here need to be protected. And so in that situation, then I think a variance process would be appropriate. Now, there certainly is an opportunity in the variance process in consultation with CPW to determine that there's an appropriate site within that 300-foot no surface occupancy area. And I think we've clearly indicated through the variance processes in the other discussions around variances that that's a standard procedure, that consultation with CPW and a potential determination and recommendation by CPW that those locations can happen within that no surface occupancy area, or they can at least recommend that to us. And so I would indicate that this would also apply in that circumstance.
Meaning that it wouldn't be a waiver under the rules, be a waiver under, under this rule, be a waiver under some other rule, or some other evaluation. I understand what you're saying. I'm pretty sure, Commissioner Messner, I appreciate the clarification. I think my opinion on that is that as one commissioner, I still think that the waivers at all distances for intermittent and ephemeral streams with CPW consultation is appropriate. And my last thing is in regard to the 411 BMPs in that regard, is that I might make a suggestion that we don't reference those and we just add those 4 elements as the rule, right? And so they would become, whatever the rule is, 1 through 4. And I would also, I'd be willing to entertain a specific dictated frequency for visits. I don't think daily is appropriate, but I would be willing to entertain what may be appropriate. I'd also be willing to entertain perhaps a CPW recommendation as a COA, and kind of leave it open-ended on what that frequency would be. But I do believe there's some value in having a dictated frequency, or how we're going to be determining a frequency for site visits that are, within this kind of buffer zone for aquatic habitats.
Chair, may I make a suggestion?
Murphy, please.
I think Commissioner Gonzalez, if I may streamline this a little bit and just say, I think that you could pick daily, monthly, weekly, and then say, unless the commission directs otherwise, right? And then there is an expectation, but there's also flexibility, because I think it's appropriate and to build that in. I'm happy if the commission's direction is to pull the specific requirements and put them in as subparts. I think that makes great sense. That's fine. We'll get that done kind of on the drafting side of it. The more fundamental question to me is probably what, for sport fish management waters, the question on the table seems to be, should CPW be able to waive within 0 to 300 feet of intermittent ephemeral stream segments? And take all the time you need to discuss it, but that seems to be the kind of one of the most important cruxes.
Commissioner Nanjapa.
Thank you, Mr. Chair. I think, just reminding all of us that, there's already the requirement for consultation for anything in high priority habitat, which this falls under. And so, it would be, or I would think that in that consultation, CPW is going to identify whether or not the habitat is present and whether or not, there's, so in other words, even though I think that was a good point raised that the E3C is technically for when consultation is not required, but I think in the same vein, because this is a high priority habitat, consultation is required, and they will, be looking for that. And if the habitat is not there, they would, suggest that, something different might be considered there, or if there could be a waiver. And so that being said, I would prefer that we have, if we're going to do a waiver, that it's only above 300 feet. Though I still feel like the variance addresses that.
All right. Are we at the top of the page, Ms. Murphy?
Yes, Chair. I think we've had 3 commissioners kind of pick between 1 and 2 to put a very fine point on it. And I think it's clear we have, it is unlikely to get to unanimity on this point. I'm recognizing that I don't think there's a huge amount of discord over one versus the other either.
Okay, well, help me. Who's supportive of one?
I'm not quite sure what one is, Mr. Chair. I'm supportive of waivers for 0 to 300 for specifically intermittent and ephemeral sport fish streams.
Commissioner Messner.
Just to clarify, so we're talking about just sport fish management waters.
I think so.
And Commissioner Gonzalez, you've indicated that you're supportive of a variance process, not a variance process, a waiver process only for sport fish waters. Or are you just answering this particular question?
I was sticking to this particular question.
Okay. I'm just trying to make sure I understand the question, so give me a second to think.
Commissioner Nanjapa.
Thank you, Mr. Chair. And while Commissioner Messner's thinking, I think, yeah, that helped a lot just to help me also clarify. For sport fish management waters, I am comfortable if we were to go down this path, knowing, as you already know, I won't beat that into everybody's minds about where I stand on the variance versus waiver. I also just wanted to indicate support for what Commissioner Gonzalez said about just putting those 411 measures in this rule as opposed to that reference.
Commissioner McGowan.
Thank you, Mr. Chair. If we're just talking about the sport fish management water, I can support number 1.
Okay, so Bill's there, Commissioner McGowan's there, I'm there, Commissioner Messner, Commissioner Nanjapa, what are your thoughts? Commissioner Nanjapa.
Sorry, just a quick clarification, because we also were talking about whether or not gold medal waters would be included here or elsewhere. To fully support number 1, I would want gold medal waters to be outside of the sport fish management waters.
And what would you like gold medal waters to receive?
Well, my previous proposal was putting them in with cutthroat trout.
Chair, if I can pull us back, I think I heard broad consensus from commissioners that gold medal should receive a 500-foot NSO.
Anybody disagree with that? Okay, so that's green. Let's leave it green. And then I think we have consensus on 1 for sports fish management waters. So let's turn that green. So do we want to go up to cutthroat?
I think that's a good idea, Chair.
So we've got option 1, 300 feet with intermediate buffer to 500 with 411 A2B 1, 2, 3, 4, and 5, not 3, or 500 foot NSO with variance. Commissioner Gonzalez, you're unmuted. Would you like to provide some perspective?
Didn't realize I was unmuted, but
now I'm going to pick on you.
Sure, go for it. Yeah, I'm still supportive of option 1 for the cutthroat. I don't think the impact on the regulated community is going to be substantial, whichever way we go on this. Where it comes to my decision on the 300 versus 500 and what we pick for the NSO and what we allow a little more flexibility on, really just goes to the necessity of the buffers. And I was kind of influenced by all the stakeholders and by CPW as well. And I think what it came down to that necessary question is 300 is necessary and 500 is better. More is maybe better, but I want to stick with what's necessary and reasonable. And that's kind of where I stand voting for number 1.
And in doing that, the way it's drafted with intermediate buffer, is that a CPW waiver, a director exception, and then our consideration at OGDP?
Yes.
in your mind?
Chair, may I follow?
Yes, please.
And Commissioner Gonzalez, I did us all a disservice in creating kind of different language and different subparts. Is it correct to summarize option 1 as being akin to what has just been agreed to for sport fish? You want me to scroll down?
No, not entirely. I think with the sport fish, I think the ephemeral and the intermittent and ephemeral for sport fish with that that waiver availability from 0 to 300, I think is appropriate there. I do agree that cutthroat should deserve a little more protection, so maybe a little less flexibility is where we find that middle ground there. And so I would suggest that for 0 to 300 for any stream for cutthroat waters would be on the variance side. So the waiver is within that intermediate zone. The hard protection is at 300 with a higher hurdle, I guess, through the variance process, which may or may not be a higher hurdle. In practice, we don't really know at this point, I don't think.
Yeah, you could add that, Director Murphy, that variance for the 0 to 300. Let's let Director Murphy get caught up before I turn to Commissioner Messner.
And let me confirm that it's correct with Commissioner Gonzalez.
I think you're going to have to make sure it's correct with all of us here in a second. So,
Oh, I want to start with the proponent though, because if I screwed it up for you, there's no hope of getting to anybody else.
yes.
Thank you.
Commissioner Messner?
Thank you, Mr. Chair. I mean, and I do want to confirm that this, also includes the provisions in the waiver consideration that was proposed by WRLG, which is to ensure that it is protective of wildlife resources with the waiver. So, I mean, I think that's inherent. I just wanted to confirm that was the WRLG proposal. Well, and I think in the original language too, so I may be conflating things here again as well, but there was language in there that said protective, to make it sure it's protective of wildlife resources in the waiver provision between 300 to 500 feet. And if that is the case, then I can be supportive of the 500-foot NSO and the 2 bullets under this one for both cutthroat trout and aquatic native species, because I think we heard earlier that aquatic native species are also very critical and their habitat is critical, and cutthroat trout inherently is an aquatic native species.
Thank you, Commissioner Messner. Commissioner Gibbs, did you raise your hand?
Mr. Chairman, it was actually earlier, but I like the track that we're following right now. So really nothing to add at this second. But
Okay, I apologize that I missed you. You were on the second screen.
sorry.
Trying to balance bad eyes with screen and getting everybody recognized. Okay, so I believe we've got Gonzalez and Messner in support of cutthroat trout option 1. Do the other commissioners desire to weigh in? Commissioner Nanjapa.
Thank you, Mr. Chair. I would prefer number 2, but with, I guess I'm not sure if we could spell this out, but with the 411A style BMPs, as we're talking about with the other ones. So it would be a variance process, but it would be required. That would be a part of a mandatory requirement if a variance was sought. I'm not quite sure if we can do that. So I'd look to the legal counsel or to Director Murphy on that. But if we do a variance, I would still like to see those be always required, the 411 measures that we're considering for other pieces.
Commissioner Messner.
Thank you, and thank you, Commissioner Nanjapa. I couldn't agree more with that. I do think that inherent in our variance process, has to be a showing of a no net adverse impact and creation of best management practices. And my assumption would be, in order to be able to be granted a variance, that we're going to have significantly more best management practices than is necessarily spelled out in Rule 411. And so that's where I look at it from a variance process, and the protections available within that variance process. So while I don't mind spelling it out, and I certainly, if we want to indicate that, I'm fine with it. But my reading of it would be that the variance process could very well require significantly more than just what's in 411A2B.
Commissioner Messner.
Thank you, Mr. Chair. And sorry, so I also want to confirm that the cutthroat trout options here that we're talking about apply in both perennial, intermittent, and ephemeral streams. Is that correct?
Yeah, I believe so. Okay, so Director Murphy, help me. So we've got Commissioner Gonzalez and Commissioner Messner expressing comfort for 1, Commissioner Nanjapa expressing comfort for 2, I believe. All right, I'm comfortable with 1 as well, given the sort of receipt of all the testimony we've received, and I think it is. So that's where I guess I would end up. Commissioner Nanjapa?
Sorry, just as we're continuing to discuss this, I just, one of the things that came up in our discussion the other day was that, and I think we all, know that, so with the CPW waiver, we're asking them, to come and work with the operator, and they're needing to then make a statement as to why, this can work. But in the variance process, we're asking the operator to say, here's how we can make this work. And I guess I just want to make sure we're also considering about that additional sort of request we're making on CPW with that waiver in these instances. So I just want to put that out there for discussion.
Commissioner Messner?
Thank you, Mr. Chair, and thank you, Commissioner Nanjapa, for bringing that up, because it's kind of part of the point I was trying to bring up yesterday, not very successfully, is that that as we look at waivers versus variances, that does put and I know it's not a clear burden of proof, and so I don't want to utilize that language, but it does do exactly what you indicated, is that that CPW has to determine that it's, and the operator have to determine that it's protective, right? And I think that is challenging, but in response to that, and where I scratched my head a little bit, but at the same time, I mean, this is what was indicated, is that they felt like 300 feet was protective, 500 foot was better, and so. I guess I don't really know where to go with that, except for language that we've got here.
Well, I also would just sort of remind the 5 of us that, we're creating something that is going to be new. We're a professional board that is going to be looking at permits for the first time. This is creating a three-part process in which the CPW is agreeable to a waiver, the director is agreeable to an exception, and then they convince us that this is protective of wildlife. I think we're going to have to try some of this stuff on for size and work through it. And, you know, just as Commissioner Gonzalez mentioned earlier, how long does a variance hearing take? Well, we don't know, and we don't know how long an OGDP permit hearing is going to take either. So I don't know why I said all that, but that establishes that I'm you know, comfortable with where we're going. Others with thoughts? Commissioner Nanjapa.
Thank you, Mr. Chair. More of a question, if possible, that if I could ask Mr. Holtz or Mr. Ackerman. You know, have there been instances in similar types of consultation where, you know, there's a desire to do something different, you know, or to in a waiver type of situation, you know, where they're sort of seeking approval, where the operator is kind of questioning whether or not the decision is appropriate, or, you know, kind of pushing back. I just want to kind of better understand about, you know, what position this potentially puts you in, or if you feel it's usually a you know, just a conversation and you're working through the pros and cons. And could you just help me understand that a little bit more?
Mr. Holst.
Thank you, Mr. Chairman. Thanks for the question, Commissioner Nanjapa. You know, it actually is a full spectrum. I mean, there are a lot of circumstances where it is just a discussion and we're sort of problem solving with the operator. There are other times where it is almost, you know, a question of sort of methodology and facts, where we're presenting ours, they're presenting theirs, and it is more, you know, I don't want to say adversarial, but it is, you know, point counterpoint to the point, you know, where they're trying to, you know, achieve something that maybe we don't agree with. So it does range, you know, and it really depends on the situation and the operator. Wish I could give you a better answer, but it's the full spectrum that you can imagine.
Thank you, Mr. Holtz. Commissioner Nanjapa, did you have any follow-up?
Thank you, Mr. Chair. No, that's really helpful, Mr. Holst. I guess maybe just another question. So in the event that CPW disagrees and decides to deny a waiver or not provide a waiver, then that doesn't preclude them from still seeking a variance. Is that correct?
Mr. Holtz.
Thanks, Mr. Chairman. No, I think that is correct. I mean, I think, you know, then the commission would be faced with not having our support and a variance request, but that is certainly within the operator's rights, the way I read the rules, for them to do that if they disagreed with our sort of presentation of rationale of why, you know, a waiver wasn't appropriate in that circumstance.
Thank you, Mr. Holtz. Others who desire to weigh in on the cutthroat trout question. Commissioner McGowan.
Thank you, Mr. Chair. I think I would just like for us to be on the record, maybe Commissioner Najapa's suggestion that I think for the aquatic and the cutthroat, that the 411 BMPs would be extended. So regardless of the NSO distance that we pick or the waiver amount, is there support for extending those BMPs beyond the 300 to 500 foot buffer? And for gold medal, it would not be that case. It would just be 500. But between 500 and 1,000, do we still want additional BMPs for these particular waters? And Commissioner Nanjapa, correct me if I did not understand you correctly.
Thank you, Commissioner McGowan, for bringing that forward. In my mind, I think this was maybe a more general statement for the aquatic habitats, and perhaps if this is a separate subsection, it would be easier to address. But yeah, I think what I was suggesting is specifically for these designated stream segments, so not entirely all over the state, but for these designated stream segments that we would apply the within 1,000 feet, that those same BMPs in 411 would apply. And I was influenced by some of the information on some of the spills that have occurred, where they've gone 450 meters, which is quite a bit greater than what we're talking about here in buffers. And I did notice that where we had some of these types of things in other parts of the rule, in 200 through 600, I think we also added the hydraulically connected, so in other words, fluid could move to those areas. So I would maybe even offer that as if the topography wouldn't allow for a location that was 1,900 feet away but wasn't hydraulically connected to the stream, then maybe that wouldn't apply. But if that makes sense. Anyway, so but I do think it's a good practice. We did hear from Ms. Wazelinski that she thought that was a good practice in general.
Director Murphy?
So I feel like all of a sudden this conversation is morphed from talking about what to do with the 500 foot for cutthroat into like, do we want an additional buffer requirements for some species, which is an absolutely appropriate conversation. But if we're talking about something that's 500 to 1,000, I need a little more guidance and a little bit more help.
Yeah, I think that's fair, Director Murphy. I think at this point, if I'm able to count, 3 of us are in favor of subparagraph 1 and that process. Commissioner Nanjapa has expressed support for subparagraph 2. And we can leave it at that and turn 1 green at this point. We're not going to have consensus on everything. But I also don't want to cut off debate. But I do think the whole concept of what do we do between 5 and 1,000 is perhaps a different question. Commissioner Messner?
Thank you, Mr. Chair. I mean, I think it's a different question, but it was certainly one that Commissioner Nanjapa brought up in her opening statement. And so I think it's important that we give that as much credence as we've given everything else. And, I see value in what she's indicating as far as that, because that was testimony that was provided yesterday. And the consideration is, not a NSO, but a BMP practices, like required BMP practices out to 1,000 feet around all aquatic habitats. And so I think that can be considered. I think it could be considered separate from what we're talking about here. But I do think that was a topic that was brought up earlier that was not captured, which was one of the reasons I asked the question if Commissioner Nanjapa's full consideration was captured.
Commissioner McGowan?
Thank you, Mr. Chair. So I think in my earlier testimony, I was pretty clear that my preferred option is number 2, but I can live with number 1. So.
Okay. Thank you for that, Commissioner McGowan. And sorry that I failed to make note of that. So I think that, oh, now I'm lost. Okay. Do we want to go to this aquatic habitat BMP requirement beyond NSO out to 1,000 feet discussion now? Commissioner Nanjapa.
I'm agreeing with Director Murphy saying no. I think I would just propose that, just to finalize these other species, I would propose that, if given that there's consensus around the cutthroat with what we just discussed, to make that applicable as well for the aquatic native species.
Commissioner Messner.
Thank you, Mr. Chair. I would concur with that. I think that it's indicated that the aquatic native species are, cutthroat and aquatic native species are both sensitive. And so I would agree with Commissioner Nanjapa on that.
Commissioner Gonzalez.
Yeah, and I think I heard it pretty clear from Mr. Holtz and from others in CPW that that native species and cutthroat should receive the same level of protections. I think we built in enough flexibility with the cutthroat rule that we just talked about, and so I would support applying that same framework to the native species as well.
Director Murphy, can you scroll up so we can see all of the green cutthroat one? Thank you. And can you scroll down to sport fish management so we can see that option? Can someone explain to this tired chair what's the difference?
Yes, Chair. It's the language I've highlighted. It's the ability for CPW to waive.
Got it. Okay. Okay. Got it. Thank you. Okay. Scroll back up. Okay. So I think we've heard 3 people that are in favor of adding aquatic native species beside the word cutthroat trout so that they're done the same. Is that right?
That's what I heard, and that's why I just jumped straight to green.
Great. Okay. Everybody good with that? Commissioner Nanjapa?
I am. I saw Commissioner McGowan's hand, so I don't want to jump in front of her, but I was also wanting to make sure that we're also agreeing, or at least I would propose that we do the same treatment for gold medal waters as well, whether that's as its own separate category or lumped in with these.
Commissioner Messner.
Thank you, Mr. Chair. So I think the gold medal says right now that it's 500 foot no surface occupancy, and anything inside of that is a variance.
That's what I thought.
So I'm pretty good with the way it is, because I think it is more protective than, and I'm not saying that it necessarily should be more protective. I mean, to me, the difference between sport fish waters and gold medal waters mostly has to do with gold medal waters. The fish are just a little bigger, right? I mean, there's tons of sport fish waters out there that has the same volume of, or close to the same volume of fish, which is why I was asking those questions earlier about that, because I'm trying to understand really the difference. I also think that the percentage of gold medal waters that actually are potentially impacted by oil and gas operations is minuscule, whereas the potential impact to sport fish waters is higher. And so having said that, I'm fine with the as is. I mean, I'm fine with it as is, but I mean, to me, these can all be treated exactly the same if we want to do that, because it seems a little awkward to have the sport fish waters have like a little less protection and the gold medal waters having a little more protection, but I'm okay with it the way it is.
I am too. Director Murphy, do you want to just make sure that we're blatantly clear and type out anything within 0 to 500 as a variance? Commissioner Nanjapa.
Sorry, I just wanted to make sure that I was clear, because maybe the current rules, I think, were referenced, where gold medal waters are in the current rules that are being implemented right now. But in the draft rules, gold medal waters are nested within sport fish management waters. So I just want to make sure, are we treating them like the cutthroat and aquatic native, which is what I was trying to say, or are we treating them like sport fish? Are we making them a separate category? So that's where I want to just make sure 100% clear.
At this point, I think we're making them a separate category if we go with what is being proposed here. And I'm comfortable with that. I agree with you, Commissioner Messner, that there's not a lot that are implicated. I looked at that map just the other day. But it would be the Colorado River, and I think the North Platte at a minimum. Commissioner Nanjappa?
Sorry, so I just want to, again, just, you know, as Commissioner Messner was saying, gold medal waters, you know, we're talking about the volume of fish, the size of the fish, but these are the non-native species. So why are we doing more protective measures, you know, less options for waivers than for our native species? I just want to understand that.
Commissioner Messner.
I mean, it's a good question. I mean, I think that I think what we heard is that the preservation of those gold medal waters from the CPW perspective is critical from their perspective. I think that I think personally, both sport fish and gold medal waters need to be treated the same. I mean, I think these all should be treated the same, but I've already said that. And I think that there's just very limited sections where you have that combination of volume and size, and it's hard to maintain, and it's hard to, and they're very economically valuable to the communities in which they lie. And so, but I would leave it to CPW to suggest whether I'm accurate or not, because that's really not for me to say.
Mr. Ackerman, did you desire to weigh in? I see that you visualized yourself.
Thanks, Mr. Chair. Just in the event that you wanted me to.
We do.
Yeah, I think Commissioner Messner got to exactly what we would say, which is what Commissioner Joppa said is accurate from a species protection standpoint. That makes a lot of sense. That you know, in this case, we'd be protecting large non-native species, but these are segments that are pretty limited, 320 to 330 miles in the state. And they're pretty decent economic value and recreational activity to the state. And so you're protecting kind of user experience there more than your habitat value.
Thank you for that, Mr. Ackerman. And as a fisherman, I can tell you that that's the case. And people come here from all across the nation and the world, and oftentimes they're looking at the map that is the gold medal waters, and they concentrate on those waters. And you know, I think we heard fair consensus amongst all the parties, including industry, that these deserve the greatest amount of protection. So that's why I'm comfortable with making it a standalone at 500 with a variance process if you're trying to get closer. Okay, we've got this in green. Is anybody wanting it to be turned back to black, or are we good? All right, seeing no objection. Are we turning to aquatic habitat BMP requirements beyond NSO, perhaps out to 1,000 feet with the 411 type stuff? Director Murphy?
Yes, Chair, I think so.
Fly around me.
Yes, Chair, I think the pending questions for the Commissioner, the aquatic habitat BMP requirements beyond the NSO, Kinder Morgan language, compensatory mitigation fee, and then anything else we want to talk about. If you'll bear with me, I'm going to pull all of the outstanding issues down together so there's less confusing scrolling by me all morning or all afternoon now. I will need guidance from commissioners about whether it's, oops, sorry. a question of the 411 BMPs that we continue to reference, if that's the right list. I think that that's what I heard from the parties requesting us to broaden the applicability of buffer zone requirements. But I would defer to what the commissioners actually heard and what they would like to see.
Commissioner Najapa.
Thank you, Mr. Chair, and thank you, Director Murphy. I think what I heard and what I am suggesting is essentially any location out to 1,000 feet from these aquatic habitats would be required to follow those 411 A2B measures. And perhaps if we do that, then we wouldn't need to put it in the other, categorical species designations that or whatever the language that we just agreed upon, because this would apply no matter whether you were, 750 feet or 250 feet, so I'm just, that's what I would suggest. And like I offered a possible clarification, knowing that there are topographical issues of hydraulic connectivity, which I saw in some of our other 400 rules. And so that would make sense to me to, if they're hydraulically connected, that we would make that requirement, knowing that 1,000 feet could take you into a whole different area.
Commissioner Messmer.
Thank you, Mr. Chair. So I would be a little uncomfortable with applying just the 411 principles between the 300 and 500 feet, because I do think that I think that we've got the ability, or CPW has the ability, to ask for more best management practices in order to be protective in that zone. And I wouldn't want to preclude that by just limiting to this, but I am supportive of having these provisions in 411 A2B 1, 2, 4, and 5 between 500 and 1,000 feet. Does that make sense?
Commissioner Gonzalez.
Thank you, Mr. Chair, and that's how I understood it too, Commissioner Messner. I think that the protections in 411 are substantial, and I think they're extremely beneficial, and I think they're used in a lot of instances of just regular best management practices, but I don't know to what extent. And I think my concern with an expansion out to 1,000 feet and just a hard mandated application of these 411 requirements, I don't understand the impact of that. And so that's my only hesitation in that regard is what's going to be the impact on the ability to execute on this, but perhaps the director could share with me if this is something that you're seeing as a regular best management practice for most oil and gas locations, just in general, in which case I'm going to be more supportive of it. And otherwise, are these the type of best management practices that in the case of the appropriate hydrological conditions, that staff would require those as BMPs or COAs in an OGDP otherwise, regardless of whatever distance we choose here?
Director Murphy, do you and or any of your staff desire to respond to Commissioner Gonzalez?
I would like to. I think there's one thing, there are a couple of things. One, at some point I would like to circle back to Commissioner Najapa and see if I've actually correctly captured what her vision is. Two, I will absolutely need Greg's help to answer Commissioner Gonzalez's question. And three, I would like to temporarily stop sharing my screen and let Caitlin share the Rule 411 A2B language so that, and maybe I can get her to send that to me so I can copy and paste it in here so we understand what the specifics are that we're talking about in terms of BMPs. I think it's like no pits, line berms, and inspection frequency. I remember those three off the top of my head, but that's only 60%, which is a great batting average, but not good enough for this work.
Okay, let's swap the screen share. I think that's a good idea. AAG Stafford, I believe you're at the plate.
Can you all see that okay?
Yes. So Commissioner Gonzalez, did you have feedback now that this is up? Or I guess we're still kind of trying, maybe we need to hear from Mr. Duranlo, who has visualized himself at the bottom of the page.
Thanks, Chairman. I'd be happy to address that. And, you know, these provisions were established with current Rule 317B in the 2008 rulemaking. At the time, they were pretty novel. They were you know, kind of stretching as best management practices. Since that time, this type of operating practice has become far more routine. So establishing an area with down gradient perimeter berming is pretty common on a location that's near any water, whether it's an irrigation canal, a river, stream, or anything else. The lined containment devices are, I believe, required statewide right now. So that's actually not a stretch at all. Daily inspections are often, rather than using daily inspections, oftentimes operators where they won't get to sites more frequently that might be in a hydrologically sensitive area, they might use SCADA and you know, remote monitoring and remote shut-in capabilities to address that sort of risk profile. The spill response equipment during drilling and completions, I'm not sure how common that is on a day-to-day basis, but that has not been problematic for operators to implement when we've asked them for it on a site-by-site basis. And you know, obviously pits are continue to fall out of favor as an operating practice, so it's you know, not too significant a stretch for that either. So I mean, I think all of those really are representative of what's becoming more standard operating procedures than really stretch requirements.
Thank you, Mr. Duranlo, for that explanation. With that, do commissioners have thoughts? Commissioner Messner and then Commissioner Nanjapa.
Thank you, Mr. Chair. And so I'm going to put my foot in my mouth here. And, you know, as I analyze this and I analyze the potential impacts, you know, out to 1,000 feet, I think there may be some unintended consequences with the rigidity of utilizing this specific suite out to 1,000 feet. I still think completely and totally appropriate utilizing it out to 500 feet. My suggestion would be to modify that. And I still think that there should be potentially some additional best management practices between 500 and 1,000 feet suggested, but I'd like to modify my suggestion at least to allowing CPW to suggest additional best management practices based on the protection of aquatic wildlife habitats.
Commissioner McGowan. Oh, actually, I think I had Commissioner Nanjapa next, and then we'll go to Commissioner McGowan.
Thank you, Mr. Chair. I appreciate what Commissioner Messner was saying, and you know, I'm trying to think about, you know, what those unintended consequences might be, though. I guess I am, you know, just heard from Mr. Duranlo that most of these are pretty standard already. Commissioner McGowan asked this of the industry, and Dave Coolman, said that they would be open, they thought that that was not they were not immediately against it. And Ms. Wasilewski also said the same, that these are good practices around, aquatic areas. And I believe Commissioner McGowan was asking specifically beyond 500 feet. So I guess and then also, we heard the testimony that the spills that have been documented in the last 5 or 10 years or whatever it was, some of them have been, 450 meters or greater, which is a lot greater. So I think potentially by adding this piece about if the site is not hydraulically connected to the water, then it wouldn't be required. And that's where Director Murphy's got the unless topography demonstrates no connection. So that would create somewhat of an exception, in those instances. But anyway, I guess what I heard is that it's not much of a stretch. It's what people are already doing. The industry already is also saying, they don't feel it's a bad idea. So
thank you, Commissioner Nanjapa. I'm going to just go out on a limb and say I agree with you, and I think we should adopt this rule. Commissioner McGowan was next.
Thank you, Mr. Chair. And I'm not trying to complicate things more. I guess I was thinking too, we could make the requirement for the 500 feet to 1,000 and best management practices for the cutthroat and the native aquatic species, since those are, from our discussions, the most sensitive species and those that we're trying most to protect. So I think that could be an alternate to 1, which is instead of all, the native aquatic and cutthroat. And I think we're talking about the 500 to 1,000 because we already had decided what happens between 3 and 5, correct?
I think so. Commissioner Messner.
Thank you, Mr. Chair. And please understand that I do believe in application that all of these things are appropriate and important between 500 and 1,000 feet. My consideration had more to do with the potential impacts to recycled water on the western slope, and because it does explicitly ban pits. And I guess I just don't know the implication of that. And so that's why I reneged a little bit on my initial support, because I just don't know the implication of that. And so, one way to potentially do this would be to put may in there instead of shall, which means that CPW could certainly implement all of these, but it would still create the opportunity in a recycled water situation to consider that elimination of that one segment of it, if appropriate and protective. But that's the thing that kind of hung me up. And maybe there is no recycled water pits $1,000 or 1,000 miles from 1,000 miles, 1,000 feet. Of aquatic habitat. I just don't know the answer to that. So that's my pause there.
I appreciate that point, Commissioner Messner. Commissioner Gonzalez.
Thank you, Mr. Chair. And I mean, I share those same concerns. Is kind of what I kicked off with. Would there be an appetite for maybe including somewhere in the SBP that the commission or that the director will consider these COAs from 500 to 1,000 feet were appropriate? I have concerns about the impact that I don't know about, whether it's on the western slope, on the Front Range, or across Colorado as it applies. That's my one concern. I think it's a big concern. And then secondly, I think there's a mechanism that already exists here, and I think that we can make it clear that that would be considered. And I guess my third point is that we had some pretty big consternation about connectivity, if I recall correctly, and probably not in the same context when we were talking through the 900 series rules and ground contamination. I know that was a different type of substance movement, but I felt like there was a lot of concern about the lack of surety associated with that kind of description similar but different than this hydraulic connectivity, or at least in my mind. So I'm wondering if there's a way that we could accomplish this where appropriate through a different mechanism that's not a hard mandate.
Commissioner Messner.
Thank you, Mr. Chair. I mean, I think that the potential mechanism for that is to put may in there. So it would just be for a location between 500 and 1,000 feet of aquatic habitat. The commission may require the elements of Rule 411A2B to be incorporated.
Commissioner Nanjapa, and then Commissioner Gonzalez.
Thank you, Mr. Chair. A question for Commissioner Messner. So is the reason we're specifying 500 to 1,000 because in your mind, these would be required within 500 feet per what we just discussed? And so you're saying then for that additional distance, it would be more of a maybe depending on the situation kind of thing?
Commissioner Messner.
Yeah, for two reasons. One is I think that we have the ability between 300 and 500 feet to not only ask for these, but additional BMPs based on the protection of wildlife and the CPW waiver of that setback inside of between 500 and 300 feet. So I don't want to preclude the additional BMPs that may be necessary by just mandating these particular BMPs. And so I want to protect that. And so between 500 and 1,000 feet, the may would be to just enable us to be a little more pragmatic in our approach and, certainly suggest that all of these things are probably going to be required, but there may be circumstances, and I'm thinking particularly around recycled water or something like that, that may need to be considered. It would give us the flexibility to do that.
Mr. Chair.
Commissioner Nanjapa.
Thank you, Commissioner Messner. I think that helps. I guess the way that I'm thinking of the less than 500 feet, it is one of many potential BMP requirements, but I guess it seems to me we'd want to be firmer, but though I do see what you're saying about, and I do appreciate especially the point you made about recycled water that, so maybe what we're saying is that either we or CPW may recommend the application of these measures if you're within 1,000 feet. Is that what we're kind of saying, depending on the conditions, or is that where the may falls in?
Mr. Chair?
Yeah, please, Commissioner Messner.
So for me, it's the may is only between 500 and 1,000 feet. The shall is between 500 foot in.
Commissioner Gonzalez, I think you've had your hand up.
Thank you. Just another point of clarification for Commissioner Messner. If we do the may, does this mean that we are requiring CPW consultation on any sites 0 to 1,000 feet from any water stream?
Commissioner Messner.
Thank you, Mr. Chair. I think the answer to that would be yes, because I guess I don't know. I'm open to thoughts and suggestions and comments on this, but I think that, we're going to utilize CPW in consultation for a lot of different elements of oil and gas development plans. We're going to use, staff's expertise. We're going to use a suite of expertise in order to determine, what conditions of approval may be incorporated in an oil and gas development plan. And so I guess on this particular situation, if we are, in my mind, the default would be that we're going to apply all of these things to an oil and gas development plan unless there's unless there's a site specific reason or a particular application reason that it would be problematic to apply them, because these are best management practices. These are things that industry seems to indicate that are standard operating procedures, that these are, you know, ways to be protective. And so these are, that's kind of where my mind's going with it.
Commissioner Gonzalez.
No. Thank you, Mr. Chair. No, and I appreciate that clarification. That's kind of the way I saw it going. I still go back to what I think is probably the best approach in my mind as one commissioner, is that these are, you know, every OGDP is reviewed by staff. They're going to be looking at it. They know that we're concerned 0 to 1,000 feet. And so anything there, they're going to have that opportunity to address those COAs, those BMPs as necessary, as appropriate, and ensuring that it is standard operating procedure for all the operators. And I don't know that I got that for every operator in every instance, that it actually is standard operating procedure. And again, that's a point of hesitation on my end for this particular rule as proposed. And so kind of that's where I'm sitting on this matter, is I think these are reasonable things. I don't know how reasonable they are for all operators in all situations, and it's a lack of knowledge that I'm not comfortable making a mandate on based on that. And I think that there are just a myriad of ways to incorporate this in the OGDP through what staff is already looking at. So that's my 2 cents in the matter.
Thank you, Commissioner Gonzalez. So, Commissioner Gonzalez, you would not be in favor of the rule and let it be done on a case-by-case basis via the director and staff as they make a determination, because they've got the ability to put in BMPs through the OGDP review process. Do I have that right?
That's my position.
Okay. And then I think I hear Commissioner Nanjapa with the position that she would want this in the rule. And I think I've heard from Commissioner Messner that he would like it to be a discretionary may. Do I have your 2 vote counts right, at least where you are right now, Commissioner Nanjapa?
Thank you, Mr. Chair. I'm okay with the way that Commissioner Messner was framing it, and would maybe just want in general clarification in the SBP that, you know, in either case, whether you're within 500 or between 500 and 1,000, that these are, that additional BMPs may also be required. But yeah, I'm okay with the way Commissioner Messner framed it.
Commissioner McGowan?
I'm okay with that as well. Supportive.
Okay, I can be supportive of that as well. So I think we've got a majority in that position, which is fine. Do we want to give Director Murphy a little chance to clean this up and then turn it green?
Oops. Is that right? I ask with a giant question mark.
Commissioner Messner?
Thank you, Mr. Chair. Can we bump up to, let's say, cutthroat habitat quick? So, and this is where I just want to make sure that we're not precluding anything, because in the cutthroat trout, for example, and then in turn because of that, the aquatic native species language, we're actually having mandatory 411 A2B BMPs. And in the 1,000-foot, we're saying it may. So my suggestion would be to say between 500 and 1,000 feet would be the may, because we've got the shalls inside of 500 feet. Does that make sense?
I think that does make sense. Commissioner Gonzalez?
Thank you, Mr. Chair. And that, yeah, that absolutely does make sense for better clarification of that rule. And I think that I may find some more comfort in this rule if perhaps the unless hydrology demonstrates no connection if perhaps that was when appropriate, given the hydrology of the whatever area site. I think that makes it a little more on the commission staff to demonstrate the need for it versus the operator to demonstrate the need not to have those things. And I think just given the uncertainty I have around the application here, I think that I'd be more comfortable with that language. You know, that being said, I've already been voted down for, so I'm just offering an amendment.
I'm good with your friendly amendment. Look at that. Solid work there, Mr. Gonzalez.
Can I move on?
Yes, please.
I'm very eager there. Which brings us, I think, to inclusion of Kinder Morgan language.
I'm in favor of option 2. Commissioner Messner.
All right, if we want to do it thumbs up, we can do it thumbs up, but I would agree.
Commissioner Gonzalez, Commissioner McGowan, thoughts?
I still support option 1. I think it's the better approach in my opinion, my sole opinion. But I think that option 2 is still appropriate and would be workable. So,
Commissioner McGowan.
I can be supportive of option 2 too, and I guess just suggest that we keep our eye on how the variance process is working and see if we need to make any improvements or tweaks as we work our way through the process. I think that some of the arguments for industry are seem fair to me, and so let's just keep an eye on it and see as we progress what this looks like and whether any of these concerns come to fruition.
I agree with that point, and I appreciate you making it. Commissioner Najapa.
I support, and I just wanted to maybe suggest that in the SBP, as this kind of relates to the places where CPW is involved in various consultations or, helping to determine whether the appropriate habitat is available and that kind of thing. I wonder if in the SBP we could have a bit of a flow chart of, like, if you're in high priority habitat, which is what, the primary language suggestion had been, from Kinder Morgan, was specific to that high priority habitat section. So if you're in high priority habitat, there's automatic consultation. You have to do the ALA. You've got, these options that give you the off ramps. And then, I'm just wondering if that would be helpful just to kind of really lay that out for, maybe that's in guidance or instead of SBP, but just to help everybody remember which sections, kind of apply or where their different, off ramps are through CPW's consultation.
Director Murphy.
I think that we can add clarity to the statement of basis and purpose to kind of try to help walk through these processes. I mean, I think there's probably a more global need for us as an organization to put together kind of a flow chart as a bigger picture concept. And I think the other component of this is that we're all going to be learning together about this new process, right? Not just staff, not just commissioners, not just all of our affected stakeholders. And so I think that some of this will also become more apparent as we work through it, or how the pieces fit together. I mean, I think Commissioner Gonzalez could probably walk us through how it will go, given his experience in this space. But yeah, I think we'll figure it out. And I think, yes, we can provide more clarity. Commissioner Najapa.
Great, thank you, Director Murphy. Who would like to lead us into the compensatory mitigation fee discussion? Commissioner Messner with a quick hand.
Yeah, it's not going to be as exciting as you think it is. I'm not ready to quite go there yet. Can we roll back up just to the last green language that we did before this one? Right here. I just want to make sure that this is what Commissioner Gonzalez wanted. And so it's for a location between 500 to 1,000 feet of an aquatic habitat. Commission may require 411 A2B 1, 2, 4, and 5 for inspection and inspection BMPs to apply at a minimum when hydrology demonstrates BMPs are appropriate. Is that what you were looking for?
Well, I mean, not exactly, but that makes it more palatable. I think the at a minimum language is probably a little too strong there. If we're mincing words here, when the hydrology just demonstrates it, again, I just think that language needs a little bit cleaning up. But generally, that's kind of the intent that makes it a little more palatable for me to apply it in a way that the site demonstrates it versus a presumption that it's needed and the site demonstrates otherwise. Does that make sense, Commissioner Messner?
It does. So, I mean, I do think that this kind of captures it, but when you say it that way, I just wasn't sure what you were saying is what this was saying. And so I just wanted to kind of make sure that was the case. So. I'm done with that one.
On this, are we comfortable leaving this as is? Commissioner Gonzalez.
These are not final rules, right?
No, and we need to start talking about how we're going to get through the rest of the day too, because we do need to try to get the final rule today. And these are just all, thoughts on a piece of paper. But let's try to get through the piece of paper first. Okay, I'm not trying to rush folks, but I would like to turn to compensatory mitigation fee discussion. Commissioner Nanjapa.
I'll jump in on this one. I think there was a comment made by industry that this was not, or changes to this were not proposed, but the fee itself was in the rule. Anything in the rule is, subject to, our discussion. And I think we did have some, parties that were suggesting, lower fees. So I think it's also appropriate that we're thinking about higher fees. So all of that said, I also did appreciate, though, that there might be some value in some sort of work group that, looks at these different valuations and what might apply. And for me personally, I think not now, but in the future, we might want to consider an aquatic habitat specific compensatory mitigation fee, in those small situations where that could apply. It would be useful because that's going to be a different and probably more expensive situation. The other thing I just wanted to note is that part of the reason that I kept getting on this topic of compensatory mitigation is just that there are, some species where just simply restoring the equivalent amount of habitat somewhere else is, helps out that species, in the same way. And so there's some value in all of this, and just making sure that, what is being put in to the kitty, so to speak, is going to help CPW get their work done. So all that said, I would support I think it was the option 2, the 17,000 level flat fee. And then, a work group to think about, I appreciate that Director Murphy added the regional, because I think that's also another, something to consider, or aquatic scenarios, where there might be something different. And maybe in those scenarios, a per acre would make more sense. But yeah, I would support option 2.
Commissioner Messner, sorry, I muted myself.
Thank you, Mr. Chair. And thank you, Commissioner Nanjapa. I appreciate that analysis. My big concern about the compensatory mitigation fee, and it's kind of what I indicated before, is, it's only effective if the projects that you're doing actually create, a no net loss, and that they're effective, and that you've got enough money in order to do those projects in order to be able to make them effective, because the implication of not having enough money to do the projects to properly compensate or mitigate for these impacts is that you're going to have a net loss of habitat and or net loss of or be less protective of the wildlife that you're trying to protect. And so while I appreciate the analysis in order to determine the initial proposal for the fee, what was compelling to me is that as I look at this, and I think in most situations, the impacts really have the potential to be generally long-term impacts. And so I think if I remember correctly, option 3 took the same dollar amounts that was associated with option 1 and applied it to all be long-term impacts. And to me, that was the most logical approach to that, if I'm correct with my options there. And so that actually made the most sense to me. Not that we're trying to like overcharge anyone or not trying to bring in, you know, the $1 million an acre Pitt and County examples, but to take the general dollar amount associated with option 1, but apply it only as a long-term approach or a long-term impact. And so that was compelling to me. I'm certainly open to hear other commissioners' thoughts, but making sure that this is done right to me is critical, because otherwise we're inadvertently creating you know, net loss of species or habitat based on the compensatory mitigation approach, which is what we've seen in a totally different situation with payment in lieu for affordable housing, whereas in a lot of situations, the payment in lieu payments were not enough to actually offset the affordable housing. And so therefore we had a net loss in affordable housing in many communities around the nation. So.
Commissioner Gonzalez and then Commissioner McGowan.
Thank you, Mr. Chair. First of all, I'm a per acre. I believe it should be a per acre and not a flat fee for the sole reason that I think a flat fee just it impacts smaller operators and smaller operations a little bit more than it would, you know, potentially what is a more impactful operation for a larger pad. So I think there's a disproportionate impact in that regard. So I would advocate for a per acre basis. That being said, you know, I think that there's a potential hybrid approach. I think that the points Commissioner Messner made about no net loss is a really impactful one. I don't know how we quantify that other than just picking a bigger number, and I don't know if that's the right approach. An approach that I might suggest is a per acre basis based on the fees that CPW calculated and suggested and felt appropriate and necessary, with a caveat in there that CPW may raise the fees to ensure a no net loss for any given site. I don't know how much flexibility, that discretion, you know, if there's any unintended consequences with that, happy to hear about it. But I think that might be an appropriate approach to say, hey, here's the baseline that CPW thinks is correct. We'll apply it on a per acre basis. And that goes for short and long-term disturbance. And if there's any potential for a net loss, that those fees could be adjusted upwards. I would also suggest a second prong to that, which would be an annual revisit, similar to what we're doing with maps, where we revisit this fee on an annual basis. Property prices change. They're going to continue to in Colorado. I think some sort of escalation is appropriate. I don't know that there's a mechanism we can build into the rules as is, but if we evaluate that on an annual basis through a rulemaking, I think we could also take a look back on the prior year through the director's report on what actually went down with the compensatory mitigation. Did it work? Didn't it? And it just allows a little more flexibility to really not zero in on what may or may not be the right number now, and make it right as time goes on.
Chair, may I follow up?
Yep. Director Murphy.
Thank you. I think, Commissioner, if memory serves, we did address that the fee needs to be updated frequently, but we didn't build in a specific way to do it, thinking that we could fold that into the mapping updates or other rulemakings. If we want to formalize it, totally your discretion. I just have like kind of a reminder kind of rattling around in my brain that there is a discussion of that. I need to find it. Two, I hear you on the per acre fee, Commissioner Gonzalez, but I didn't catch if you had a specific option or dollar amount that you thought was appropriate. And then the third one is Commissioner Mesner, I heard your discussion. I think what you were proposing is the per acre fee, maybe option 3, but I didn't capture if you had an actual, like, this is what I think we should do. So a smattering of questions coming back to all of you.
Let's just go work in reverse and go to Commissioner Messner first.
Thank you, Mr. Chair. So what I did suggest, because I was indicating that I thought all impacts should be considered long-term, and as I look back at it now, that is option 3, which is a flat fee based on average disturbance and all habitat loss assumed to be long-term. And that does not take into consideration, I mean, that doesn't take in the Pickens County outlier. So that's utilizing the initial fee calculus, but applying it only long term. Having said that, I'm also open to that option 3 being calculated on a per acre basis instead of a flat fee.
And if Commissioner Messner, if you did that, what would the number be?
It would be $5,295 per acre.
Director Murphy, I don't know if I need to go to another commissioner to answer questions or if I can move on to Commissioner McGowan at this point.
I think Commissioner Gonzalez filling in the blank on the fee would be helpful for me if he feels so inclined.
Sure, I do feel so inclined. It's the same short-term and long-term fees as presented in the draft rules. I can read those out. I've got them here. That would be for, oh, I'm sorry. The draft rules contemplate the flat fee and the site-specific determination. It would be the ones proposed in option 1 would be the per acre short-term and long-term basis on the cost to mitigate. Was that all of your questions, Director Murphy?
Yes, thank you, Commissioner.
Commissioner McGowan?
Thank you, Mr. Chair. For option 4, I think my only concern is if I'm an operator, there's really kind of this open-ended question then of determining a higher fee, and I might not ever have kind of know what that is. And so there's a trade-off for an operator having some sort of clarity and confidence of knowing what that fee is going to be. So I just throw that out there for thoughts. I don't know if anyone else's screen is going blank on the screen part-time. Okay, just making sure that wasn't just me. Okay.
It's me.
It's all of us.
I guess I was leaning toward the flat fee, but adjusted to mitigate and weight more the long-term impacts. And so I was leaning toward option 2 or 3 flat fee.
AAG Davenport, could I see you, please? We received in closing some fairly robust discussion or closing from some of the industry components that they had all along been one approach, and then here at the end, we are now contemplating other approaches, and that they felt that was unfair or violative of the APA. As we're looking at these various proposals, could you weigh in on that concern that was broached?
Yes, Mr. Chair. So I think there may be 2 issues in that regard. One is a scope issue. I the compensatory mitigation fee has been part of this rulemaking since it was initiated. I don't have a scope concern with that. I think given that there have been discussions and proposals about potentially changing that fee throughout this process as well, though I recognize that there was significant discussion later in the process. I think once it's in the scope, the commission can consider different proposals. Perhaps parties may not have anticipated that the commission would consider different proposals later in the process. In my view, that isn't something that, or that isn't a commission issue. In other words, the commission can consider the proposals that's been made to it, in my view, on this.
Okay, thank you, Commissioner McGowan.
Thank you, Mr. Chair. So I think I'm a little surprised that industry is surprised, because there was talk of the fee in some pre-hearing statements. I believe I asked a question about it with the affiliated local governments when they made their presentation. I could be misremembering my own questions. And then when the opportunity came for the commissioners to all bring up things that they wanted to discuss, I brought it up how we normally do during our process. So I feel that we've followed the process that we have with many other issues during these series that we've been contemplating.
I tend to agree, Commissioner McGowan, but I did want to get that on the record so that folks that are complaining can understand what our rationale is relative to this. Hey, Agent Davenport, did you have anything else, or are you just still visual to me?
I'm just still visual. I'll go away.
Commissioner Messner.
Thank you, Mr. Chair. And I do think one of the things, and I'm not trying to be flippant by any means, but one of the things to remember is that, you know, there is ways to avoid this fee, and that's to not site within high priority habitats. And so this doesn't apply to every single permit. So.
Commissioner Nanchapa.
So I guess maybe I would propose that, you know, we just decide whether we want to go flat fee or per acre. I could be comfortable in either scenario, and then maybe decide what the level is. But I also wanted to acknowledge that I appreciated the suggestion from Commissioner Gonzalez to revisit this each year. I do think that's a good idea, and, you know, see how it's working in practice, and whether or not there are changes that need to be made, you know, for a variety of reasons.
Thank you, Commissioner Nanchapa. That could be a good approach. What are folks thinking relative to doing that first? And if so, which approach are you more inclined to support? Commissioner McGowan?
Thank you, Mr. Chair. So I think if we're heading that direction, I would support the flat fee as proposed in the rules, revisiting with CPW to figure out if that flat fee in general, because they picked an average. And so talking with CPW about if and when it's been implemented, it actually covered their cost to mitigate. And so we would know then if that flat fee was appropriate or not, and we can adjust accordingly.
And Commissioner McGowan, when you say as proposed in the rules, that's the initial flat fee that was proposed?
Yes, sir.
I agree with you. Other commissioners desiring to weigh in? Commissioner Messner?
Thank you, Mr. Chair. I mean, I agree with the, you know, not utilizing option 2 only because it takes into consideration the super high dollars in Pitkin County. And so option 1, as far as the basis for fees, I think makes sense. I'll still say that I think that these impacts are long-term, not short-term. And I really think that's an important consideration. But, you know, it doesn't sound like I'm going to have support for option 3. And so I can capitulate to what's being proposed here. But I think it's important to acknowledge that, you know, if we're wrong in these mitigations, you know, I think it's going to be, we're going to have a hard time in a year to determine the impact of these proposed sites and the mitigations. And so I'm just, I think the risk of us being wrong here is significant, and that's what gives me pause.
Commissioner Najapa.
I appreciate those comments from Commissioner Messner. One thing I just, in my read of this, I think all of these, I'm sorry, option 1 excluded the appraisal values exceeding 100,000. Option 2 excluded the appraisal values exceeding $1 million. So it didn't include the extreme ends, but it did include some additional ones. That said, you know, I'm also okay with going with what we have, but reevaluating, given that we're thinking about some of these different scenarios, regional, aquatic, et cetera, and maybe a better per acre scenario. And so I could go with what Commissioner McGowan was suggesting, to just go with what we have, but revisit, but with that additional piece that Commissioner Gonzalez added of revisiting. I do think it's too low, but I would be okay with taking a little more time to evaluate it.
Thank you, Commissioner Najapa. Others with thoughts? Commissioner Gonzalez.
Thanks, Mr. Chair. Yeah, I'd be comfortable supporting, as Commissioner McGowan proposed, with an annual revisit. And to a question Director Murphy asked that I did not answer, I do believe that could be formalized. And I think that'd be appropriate to put everyone on notice. These are going to likely increase over time, and that we're going to make the appropriate adjustments as the costs associated with compensatory mitigation and getting that land is going to change over time.
Let's give Director Murphy a quick chance to get caught up.
Thank you, Chair. I've taken a few liberties here, right, to summarize what I think I've heard. And as part of option 5, we could include, as part of a flat fee of $13,750, we would also note that in the rule that we would expect this to be updated as part of the mapping updates for high priority habitat, right? So we're folding it into the same wildlife centric conversation to kind of, which addresses issue number 3. I would pull that off. I just wanted you to know what is in the statement of basis and purpose. But maybe in the SBP, add in that at our next fee update rulemaking, which would be noticed in January 2022, that we do want to consider either regional and aquatic considerations. Does that work?
Commissioner Najapa.
Yes, I'm good with that. Thank you, Director Murphy. The only thing I would add is or possibly considering a per acre fee in that same, just so that that's all sort of part of everybody's understanding that all of these things are going to be on the table.
Director Murphy, thank you. I think that captures the issues. Uncompensatory mitigation. And so with that, I would turn to commissioners. I think procedurally we need to speak about next steps. We are needing to get through this today. It's 2:10. I think we have tackled the large issues. We have the other issues to explore. I have a couple, I bet you do too. Do we want to go into that now? Do we want to take a short break to get some food? What are folks' inclination here? Director Murphy, if you have any thoughts too. Commissioner Gonzalez.
I'm starving, Mr. Chair, and I would love to have some lunch and clear my mind before we move on to these other issues. I know I can tell you I have 2 issues that I'm going to offer up from that we've heard about, and so that's I don't have many. I don't know about everybody else, but I think we can tackle that after a short lunch break if appropriate.
I think that makes sense. Is knowing we normally do an hour, but knowing that we're going to run out of time, can we do 30 minutes? Okay,
Sure.
Let's return at Director Murphy.
Oh, can I just offer one thought as we think about what today and rolling into Monday looks like? I think that there is some homework in this document for staff, right? And if it's amenable to the commissioners and if Kyle's okay with it, I would recommend that we continue working through these issues and get direction to staff today, and then let us retreat to our rule drafting, SBP drafting corners, and put out a revised SBP and rules to you as quickly as you can. And then if we've missed the mark, we could fix that on Monday. And what I'm trying to work through is if we get directions in this document, we're going to need retreat to make those changes in the rules in particular. And then do we want to reconvene tonight to look at that? Or do we want to let staff make those changes, send them out to you to review over the weekend, and then come back Monday? So my proposal would be that we'll finish the changes, get them out to you and the whole world. And then if we miss the mark on a particular issue, we can talk about it Monday morning. However,
I prefer that proposal as well. Our weekends were screwed already because we're still working on all the other statement and basis, so it's not like it was going to be fun anyway. So let's do that, and then let's return at 2:45 for the other issue identification piece of today. Okay, it looks like all of us are still eating lunch, so just bear with regard to the chewing that's happening on screen. And I may unvisualize at points so that I can get to my tuna fish on top of crackers. All right, we are way too much information. We are ready to go. It's the afternoon session of November 20th, 2:46, finishing up on wildlife rules. We are at that place which is called other issues. And so I would invite commissioners to go around the horn and see if we have other issues that folks would like to discuss at this point. I'll pick on Commissioner Gonzalez since he said he had 2. If he wants to go first, the floor is yours.
Two quick things, hopefully quick. Anyways, the first is migration corridors. I don't think that we're ready to have these mapped and set them in the rules per se, but I do think it's important that we set out guidance about the importance of them along with the 1202D. I think that's what I'm thinking about is in relationship to 1202D. And just kind of set the stage for potential future rulemaking on that. Secondly is Western Resource Advocates' suggestion of including the words federal or Colorado to the new additional proposed language in 309E2B. I think that could be a helpful clarification and don't think that it would change any of the effect of the rule as it's written. So.
Do we want to address the issues as they're developed, or do we want to get an issue list going? What's the preference of folks? Commissioner McGowan?
I'd like to put a list together and then bang them out.
Okay, you're next.
Oh, okay. So, and I guess maybe I'd make CPW's opinion on this. There was a request for us to look at protecting open pipes, putting grates on openings to prevent wildlife access. And I guess I was curious to know if that's a big problem and if that's easy to resolve by putting grates over open pipes. And so I'll put it on the list for discussion, but I'd like some input from CPW.
That
And
may
then-
also be input from Mr. Geronimo as well, I believe.
Okay, yeah, thanks. And then I know a lot of folks have asked for broader riparian setbacks or buffers. And I feel like I'll put it on here for discussion. I will caveat it with, I don't think that we've had enough discussion overall and allowed all parties to address that issue. And so maybe it also becomes a discussion for one of these guidance or working groups that we've put together. I'll leave it at that.
Commissioner Najapa?
Thank you, Mr. Chair, and thank you to Commissioners Gonzalez and McGowan. I also had the same items that they named on 309E2B and 1202 with the open pipes. The other thing I had was in 1203, and would want to get some input from Director Murphy or staff about the request from the affiliated, I think it was affiliated local governments for consultation, or maybe it was Adams County, but it seems to me that could fit in either 1203A or maybe under B1 in the list, but just wanted to have that up there for discussion. And then I have a few other just places we could clarify the SBP, I think. And so I can either go through that now, or I'll look to Director Murphy as to whether we want to tackle those if they're not rule related, or go ahead and stick them in here. Okay. All right. So one was just the general sort of biological resources, our intent to form a work group and address that, or assuming that that's what we all agree would be useful. 309E1F. It seemed to me, this is related to the federal consultation, I think, or the consultation, I can't remember now. Sorry. 309E2F. Oh, I don't think that's the right reference. I'll have to, oh, sorry, E1F. Yeah, okay, sorry. That is where it's in consultation with CPW, how they evaluate operations on federal and private lands. And I was just thinking that it might be useful to just further emphasize in the SBP that doesn't preclude CPW from seeking or requesting additional measures. Just because there's been a few different, pieces of discussion that relate to, the federal agencies kind of determining what's necessary and just requesting a sign off essentially. Okay, 1202A7. A little bit of language that could just clarify that the exclusion fencing will be tailored, per the species that are present in the area. That was a concern of mine, and Mr. Holst answered that will be done, but I think it'd be good to clarify in the SBP. And then the more specifically on the issue that Commissioner Gonzalez raised with the migration corridors, potentially adding our intent to map within priority habitat, the pinch points and bottlenecks to the extent that we know them. And that's it. Thanks.
Commissioner Messner.
Mr. Chair, just one point, and I was thinking about this over lunch and I couldn't remember. Did we determine which elements of the variance process that we were going to apply? Did we ever do that?
Chair.
Director Murphy.
My understanding of that from this morning's conversation, and I'll roll back up to it, is that we would add language to the statement of basis and purpose that would clarify how the elements of a variance would be administered in the context of a request to cite within a 1202C NSO.
So keep all five.
Correct.
The whole elements of the variance process. Okay. And I'm fine with that. I just couldn't remember if we had determined that or not. So,
Director Murphy, can I ask you a question about that? Do you have any idea how I mean, that's kind of an open-ended sentence. Do you have direction on what we mean by that? Because I don't know that I know what we mean by that.
I think that internally staff has done a lot of thinking about what a 502 variance could look like and what the demonstrations would be. Sorry. I think I could invite Greg to talk through what his thoughts are, if that would be helpful. And anyways, that's what I was going to build into the SVP for you all to consider over the weekend. I'm sorry. I'm going to go deal with my jerk dogs.
Mr. Geronimo, I think there's an opening. And by the way, nice shirt.
Thank you, Chairman Robbins. Appreciate that. And I figured, it's Friday after 3 months of rulemaking. It's time to bust out a Hawaiian shirt. So forgive the informality. I have been thinking a lot about the variance provisions. I wish I had them prompted on my screen. It occurs to me that part of it is, the ALA would lead, the alternative location analysis would lead to the evaluation of several of the points or the provisions of the variance. And I think specifically that's sort of that first threshold item in the variance list. And then the third item in the variance list, which I think was being discussed, was the undue hardship. And I think where staff lands on that is, operating within a sensitive or a high priority habitat area, as we've seen, may take additional protective measures. It may be more expensive to operate there. It may require more analysis on the front end, so it may be more expensive to permit there. So if that hardship was limited to just a financial consideration, I don't think that would be an appropriate way to consider that. I would be looking for something for a larger, bigger picture hardship, inability to access minerals, maybe a hardship in access road construction, or significant construction required, or a flat surface area versus an area with huge cuts and fills. So a really significant difference in construction. So those were my two thoughts on sort of those specific issues that were proposed for consideration. The first would be covered by the ALA, and the second would be, we would be looking for more than just a financial consideration.
I'm muting myself. Thank you for those points, Commissioner Gonzalez.
Thank you, Mr. Chair, and thank you, Mr. Geronimo. And I think what we're trying to get at here is, when you talk about unable to comply, good faith effort to comply, or undue hardship, that some guidance around the fact that there may not exactly be an undue hardship or a failure to comply or inability to comply when choosing a more preferential site given input from CPW and COGCC. And so I think it's a way of looking at those two and finding a way to work around the plain language that's read in the rule, and provide kind of just, hey, behind the scenes, this is how we're going to look at this. If you show up with support for a better location, a more protective location, or a more preferential location through the consultation of CPW and COGCC, that COGCC is going to consider that as a good faith effort to comply, or consider that as a showing of undue hardship, something to that effect. I don't know. That's what I was getting at when I proposed that initially. So hopefully that may clear it up, at least my intention in putting that forward.
And if I may, Chairman Robbins, I would just say, I think that's exactly the intent of the alternative location analysis conducted at the early in the process. It really would say, here is the location in this high priority habitat. Here is this location that's, moved 100 feet further away, and it's a significantly worse location. I think that gets to that good faith effort to comply. We're trying to pick the best location.
Thank you, Mr. Geronimo. Commissioner Messner, did you want to follow up on that, or did you have other issues to put on the list?
No, the issues that I have, particularly around pinch points and stopovers, are in there. I've got more thoughts on it, but it's in there.
Okay. So thank you, commissioners. My issues have largely been crossed off because they're already on the list. I did have one issue as I was looking back over my notes over lunch, and I should have brought this up when we were having the variance request, but we had a pretty healthy discussion when we were talking with, I think, WRLG and West Slope, and it had to do with the concept of perhaps creating something around the use of existing locations as being preferable at times to creating a new location, and how that could play into, a variance or otherwise. I don't know if we need to rule make around that. I don't know if we need to put it in the SBP that it can be a good idea, and I don't know if there's general support for a discussion around it, but I just would put that on the list. Commissioner Messner.
Thank you, Mr. Chair. I think my feeling on it is that's covered in the ALA process, and so I don't know as it needs to be anything further than that, because that's a consideration that's being done as you're evaluating alternative locations. So,
Commissioner Nanjapa.
I think that's a fair point. I guess I wouldn't be opposed to adding some additional clarifying language in the SBP, though, also.
Commissioner Gonzalez, Commissioner McGowan, in that
Yeah,
order?
I don't think it'd be harmful, and I would support adding that specific clarification, because that's really kind of the specific scenario we're talking about, where a variance may be an inappropriate question to ask, or ask the inappropriate question, I guess. So when looking at waivers and variances, I think it's important that we consider existing locations as one of the considerations that we're going to be looking at.
Commissioner McGowan.
Yep, I agree. I did talk to CPW staff about this, and I want to caution too that they were pretty clear with me that there's a difference between where you're talking about adding to an existing location, right? So like if it's already an elect site, that's probably not going to be a less of a cumulative impact versus something that exists potentially near a riparian area. So as long as the operators understand that it's not an automatic, this is better. In some cases, it sounds like it would be not preferable to be adding to an existing site.
Yeah, I agree, Commissioner McGowan, and the discussion that I had offline with CPW, the other point being that if it's an existing location that is being used, using it more is, potentially a good idea. If it's an existing location that's not being used and then new development happens on it, that brings in all the trucks and all the other things on the access roads. And so I think at the end of the day, it is a case-by-case basis. Commissioner Messner.
Yeah, I guess I don't have very much more to add to it. I mean, I do, it always makes me a little bit concerned to get too specific in some of these things in the SBP, because I do think that's why we have staff. That's why we have the alternative location analysis. And I mean, there's certainly, I don't want to create the situation where folks think that just because there had been a disturbance in an area, even if it was in a bad area, that it's more appropriate than, utilizing some other space. And so, but I mean, yeah, I'll leave it at that.
Okay, have we sufficiently defined the list from commissioners' perspectives? Seeing nods of heads up and down. Migration corridors, pinch points, stopovers, importance to set out in the SBP. Director Murphy, do we need further discussion about this? Do you think you've got direction in terms of we'd like to do more here, but we don't think we can, and we need to wait for the development of the maps, but it is important?
Chair, I think we can convert the language that I jotted down into coherent sentences, but I want to make sure it captures what the commissioners, the scope, breadth, and intent of the language.
Commissioner Messner.
Thank you, Mr. Chair. I think what I proposed to a couple different folks around this yesterday was something a little more robust in, setting out guidance that clearly indicates that these areas should be avoided. And I know that there's some discussion about the appropriateness or not, if in the statement of basis and purpose is not, if there's not a rule associated with it. But I do think that these are, at least from my understanding from the record, that these are of critical importance. They're just not currently mapped. And so I think it's important to clearly indicate that these are to be avoided. In lieu of that, well, I'll leave it at that right now for discussion.
Commissioner Najapa.
I support that kind of general idea of, I suppose if we're saying there'd be an intent to include them in our high priority habitat, which is kind of what number 2 is getting at, or what I was kind of getting at with that one, then that would be the avoidance, section of our rules, So in other words, it would take those pinch points and bottlenecks that are known. I think I heard CPW saying that the stopovers are a little harder to map, but especially the pinch points and the bottlenecks may be easier to map. And so I don't think we're talking about the entire corridors, because there was this spaghetti map situation that Mr. Holtz had presented that in some places it's all over the place, but there are these pinch points and bottlenecks that are more kind of reliably known. So I guess I'm thinking that, or my intent here is that we are indicating our intent to map these as part of high priority habitat, so that then they will become part of the NSO, set within our rules, starting with and maybe even more specifically, starting with the 2022 map updates. And then I think Commissioner Gonzalez had offered, just rolling, into the future, just continuing to keep updating that, so that the more we know, the more we can keep mapping those.
Others with thoughts? Director Murphy?
Again, if folks are good with the language on screen, we can certainly convert it into complete sentences and make sure it actually flows with the specific paragraph.
Thank you, Director Murphy. Commissioner Nanjapa?
I'm okay with it. I think it would be good to just say and commit to by the January 15, 2022 notice of the map updates. So not just future, but specifically then whatever we have known at that point.
Commissioner McGowan?
Thank you, Mr. Chair. Sorry, just for clarification, so I know that the statement and basis of purpose is not rulemaking. So if we put a deadline in the statement and basis of purpose, does that have the same meaning it does as if we put it into the rules?
AAG Davenport?
Thank you, Mr. Chair. I think an expression of the commission's intent in the SBP is something that's important, and certainly something that that, at least in my view, I believe that the staff and the director, if the commission expressed an intent to do something, would follow that intent if it was expressed in the SBP. It's true that the SBP can't add requirements that aren't in the rules, but they are still contain important considerations, and I think staff would fall and the director would follow those, of course, deferring to the director on her interpretation of that. But also, it's a clear indication of the world to the commission's intent as well, which is something I assume that the commission would pay attention to in the future. If it had said it was going to do something in the SBP, it would make all efforts to do it.
Can I ask a follow-up question to AG Davenport?
Yes,
since it's DPW that does the mapping, is it appropriate for us to put in here that we're, adding intent to map seems like we're going to be doing the map.
Well, I think that, thank you for the question. I think the language in the SBP could be somewhat clarified to the extent that the intent is for, should CPW map pinch points and stopover areas, it is the commission's intent to include those in high priority habitat the next time it does a mapping update.
Thank you for that clarification. I think that's a better approach, and thank you for the edit there, Director Murphy. Commissioners, other on migration corridors? Turn it green. Commissioner Gonzalez?
Yeah, I just have one clarification question about, our intent to map them in HPH. That's still going to go through a rulemaking. I'm just curious what the leeway is for should the intent be that we're going to map it, or that we are going to have a rulemaking to consider mapping it. I'm just curious about the limitations and the leeway we want to leave for ourselves for a future rulemaking.
Commissioner Gonzalez?
I would say to consider mapping because I think they're important. I think, you know, we're going to try and add them to the map. We're going to find the right thing with the appropriate amount of testimony. And I want to hear more of that.
Commissioner Messner.
So I'm a little less comfortable with this because I do think that the testimony that we heard that was corroborated by CPW clearly indicated that these are, you know, high priority habitats, that there potentially no surface occupancy, that the reason that we're holding off on this is that they're not clearly mapped at this time. And so, you know, my opinion is we do two things. We either, you know, put in here the clear language that, you know, the intent is to adopt any maps that are provided by CPW that indicate these high priority habitats, and, you know, consider the suggestions from CPW on those. But the intent to, you know, incorporate these in the maps, or, you know, I would, in lieu of having pretty strong language in here, I would consider reverting to one of the initial considerations, which is to actually put this in 1202C1 as an area to have a no surface occupancy until these maps, you know, and then as the maps get updated, apply those directly. I know that AAG Davenport doesn't love that idea, but my intent on this one is to be pretty adamant that these are important areas in wildlife migratory corridors.
Commissioner Najapa.
Thank you, Mr. Chair, and thank you, Commissioner Messner. You know, I generally tend to agree. One thing I just realized is I asked the question of Mr. Randall, but I don't think, and I can't remember, it's all running together, if I got either Mr. Ackerman or Mr. Holtz to respond on whether there's any threat or concern by including those maps in a public forum, specifically for the pinch points and bottlenecks like poaching risk.
I'm looking to see if any of our CPW officers are showing up. There's Mr. Holtz.
Thanks, Mr. Chairman, Commissioner Najapa. You know, I would say that certainly in a general way, we are concerned with that, but I don't know that that would be a problem. I mean, we do have a variety of, you know, habitats and sort of site-specific features identified on our maps. You know, we've had that concern raised related to, for example, some of CDOT's crossing structures for big game. I guess we haven't seen it rise to the level of being a significant problem at this point.
Commissioner Najapa.
Thank you, Mr. Chair. Thank you, Mr. Holtz. That's really helpful. And so, given that, I tend to agree with Commissioner Messner that I think it's not just that we're considering it, that this is an intent to add these to our high priority areas, and then it would be part of a rulemaking with public input, et cetera. So that's already sort of covered there, but I guess I would lean more towards that.
Other commissioners desiring to weigh in? What do we want to do here? Go, Director.
My recommendation is that this is kind of a forward-looking concept, and that we've captured the importance of them and how we actually deal with that during the rulemaking will need to be informed by the information that is gathered between now and then. And so to me, flagging that they are important areas to avoid is the critical piece. Like paragraph 1, paragraph 2 is foreshadowing that yes, we want to do more on this when data becomes available. So I would probably be more comfortable with 2 as is, but I mean, I wait your direction.
Mr. Chair.
Yeah, AG Davenport, and then Commissioner Messmer.
Thank you. I have just a couple of things I want to submit for commission consideration. I am uncomfortable with the thought of putting into the SBP that the commission will do something in rulemaking in the future, and since that it's forecasting it is going to adopt a rule in the future. I don't think that's appropriate to say in the future. It doesn't matter what anybody says, we're going to do this rule. So I appreciate, and Commissioner Gonzalez's addition to consider mapping is well taken. That's the language that I would be most comfortable with. I do think that including pinch points and stopover areas now in the rules is one of the things to think about. Is we don't know where those may be, and we don't know how that would impact a rulemaking in the future in regard to adopting those maps. And so I share the director's concerns in this in terms of pinning the commission down to doing something in the future without having the information on it. That's, as I said, that's pretty much just a concern about the commission committing to do something in the future when we don't necessarily have all the information in regard to doing it. But that's, I share, yeah, that's all, I'm done.
Before, just a follow-up, does the consider word addition make you more comfortable?
Yes, I'm comfortable with the language after Commissioner Gonzalez's change to it.
Commissioner Nanjapa?
Sorry, not to throw a wrench in this, but well, first of all, I want to say I'm not. I didn't mean if that came out to support the idea of adding in these types of areas now, but rather, specifically with a rulemaking mapping. That said, I'm wondering, and I appreciate that clarification from AAG Davenport about, the intent to specifically do something, but could we instead say the intent to evaluate the incorporation of pinch points, bottlenecks in the next rulemaking? Is that better, worse?
Is that a question for me, Commissioner Nanjapa?
AG Davenport.
Thank you. I think to me, there's no significant difference between the two wording options that Director Murphy has just put on the screen. I think they basically mean the same thing. And to me, that pretty clearly expresses the commission's intent to say to the world, this is going to be part of something we're going to be thinking very carefully about and considering the next time we do a map update.
Commissioner Messner.
So I think two different things. I mean, I think the mapping exercise, what we heard from CPW, and please, if someone from CPW wants to comment on this, certainly do, but I think they indicated that they are going to be mapping these things and they understand the importance of them. And so this idea of considering mapping is, to me, irrelevant. It's whether or not we're going to incorporate these maps and the elements that they are mapping. But having said that, I'm also okay with just eliminating 2 altogether because, the important thing to me is that in the short term, we're actually considering these areas and we're encouraging avoidance of these areas. And, I know as an individual, I'm going to be pushing for us to have a rule making during the mapping stage that's coming up here that will consider these. And so I'm comfortable just letting that happen outside of a SBP statement.
Thank you, Mr. Messner. Commissioner Nanjapa?
Thank you, Mr. Chair. And yeah, I think at this point, I think we've all communicated our intents here. And so I'm comfortable leaving it to the legal experts to put it in the SBP as appropriate.
All right, so have we just decided to delete paragraph 2? And just go with the first point? Delete it. Commissioner Nanjapa?
Sorry, I was just going to say, I thought I heard AAG Davenport say that indicating our intent on something is helpful. So I don't know if, anyway, I would leave it to, I would defer to them, to, the AAGs and Director Murphy on what the language is appropriate. But if it is useful, especially for our stakeholders to know that this is part of not just the importance, but this is part of our intent, I think that could be useful.
All right, what are?
I think that
AAG
there's,
Davenport, Director Murphy?
for me, there's been enough dialogue on this. I need direction. Like, included or not, I'm fairly agnostic. But I do want at least 3 of you to pick the same path.
Commissioner McGowan?
Thank you, Mr. Chair. I guess I'm comfortable with the language that Commissioner Gonzalez put forward for point number 2, which is we're going to consider it in the future. So as we look at maps, pinch points and migration corridors, et cetera, will be a consideration. And I feel like AAG Davenport was comfortable with, we're not saying this will happen, we're saying we'd like to consider these things. And I think that's what Commissioner Gonzalez put down.
Okay. Everybody good with it? Okay. Thank you for extracting direction, Director Murphy.
Would it be helpful to pull up the WRA language to look at?
Probably. Commissioner Nanjapa?
I had one other piece on this one. The WRA language is pretty simple. It was just adding federal or Colorado species. Yeah, so that was actually the rule language. I think is pretty straightforward in the WRA red lines. I did think of something else for the SBP that I meant to say before and I forgot, and that is just clarifying that, as of now, the automatic consultation and the evaluation is more specifically addressing wildlife species, but that our biological resources work group would look into that for other species.
Others with thoughts about that comment?
Sorry, Chair, can we stick with the WRA? I've captured Commissioner Nanjapa's
Okay.
other point to talk about in the SBP, but let's stick with WRA right now, please.
Okay. Are we good with this proposed edit, or do folks want to talk about it? If you're good, signify by saying aye. I'm seeing thumbs up. Okay, I think you're good there, Director Murphy.
I just took a snip of the WR language to put into the document so it's clear. Okay. The look at protecting open pipes. I think we're ready to move on to that. If I'm wrong, you'll correct me. I actually asked Mr. Duranlo to take a look at this, and he had some language for consideration if this is something that commissioners are interested in considering.
Mr. Duranlo, do you want to provide us your language?
Thank you, Chairman. I do, but before I do, I want to make sure that I understand the ask. Rule 608B7, as we've modified it, or as you've modified it in this process, applies to fired vessels, heater treaters, and separation equipment. And it reads, all stacks, vents, or other openings will be equipped with screens or other appropriate equipment to prevent entry by wildlife, including birds and bats. So we have that rule on our books as it applies to, and I recall seeing a picture of an owl on the top of a stack, which appeared to be a fired, the exhaust stack from a fire tube for a heater treater or a tank heater. And so we do have a requirement to protect those. And I want to make sure I understand if the commissioner, if you commissioners are asking to address that specific issue, or if that issue is broader than that.
Commissioner McGowan?
Thank you, Mr. Chair. And I'm not sure in testimony if it was clear what type of critters. And I guess my question back to you would be, are there other types of pipes or openings where other critters are having access? And if not, then what we have in current rule, in my opinion, is probably adequate. If there's other pipes and other ways for critters to get in them, maybe we need to expand here.
Mr. Duranlo?
Thank you, Chairman, and thank you for that clarification, Commissioner McGowan. So I think where we do have other issues are like the cellars around a well, and I believe, I think it was back in the 600 series when an operator, I believe it was SG Interests, indicated that they do use protective devices around, over those cellars and provide escape ramps for critters who get in there. And so that would be one thing. Rat holes and mouse holes as well left on the site are potentials. And so there are some other ground level openings that could be covered. I see that AAG Minor has turned on his screen, and I'm wondering if he's got a rule citation up his sleeve.
AAG Minor?
Thank you, Mr. Chair and Mr. Duranlo. I do have a rule citation, which is Rule 406E. That applies to the sellers. I believe that Mr. Duranlo is talking about the preset conductor issue. Is that correct, Greg?
That is correct. And so that may be narrowly applied to the preset conductor situation and not extended to a cellar around an active well then.
So do commissioners feel we have a problem that needs solving, or are we good with the reference that Mr. Duranlo made earlier? Commissioner Nanjapa.
I appreciate Mr. Duranlo's pointing us to that part in 608. That's helpful. I think as I was actually reviewing the 200 through 600, there was a similar issue that came up. And so I don't know if it needs to be addressed there or here, but I think just any open top pipes or any, sort of pipes I think would be it'd be useful to have them, you know, being equipped with screens or other appropriate. You do have other openings, but I'm wondering if it'd be useful to just clarify that in the 600 series. So I don't know. I'm not sure. To me, I was going to suggest the same thing as it related to the stakeholder feedback in 1202A as one more measure within, you know, what's listed there. But I see your point that it is kind of taken care of in a couple of other places. The one thing in particular that I was looking at when that came up for me was the monument markers for plugged in abandoned wells that can sometimes, or that are, you know, would be a pipe that would be sticking out of the ground. And there was an issue a few years ago that BLM and other agencies were dealing with that was more, I think, related to mine markers, but it was, you know, birds and lizards in really large numbers were getting caught in those. And so I just want to make sure that that's addressed. If not here, then maybe we just need to add a word in that 600 piece.
If I may, Chairman.
Yeah, please.
So I think a couple of things on that. And so now I'm looking at Rule 406E, which does apply to conductors, and it's not limited to preset conductors necessarily. E1 says an operator will secure conductors and cellars to prevent accidental access by people, livestock, or wildlife when active work on that conductor is not occurring. So, you know, if they're not working on the well, that conductor does have to be covered. And then also, we do have a requirement that all rat holes, mouse holes, and cellars will be covered with materials sufficient to prevent accidental access by people, livestock, and wildlife. So that is covered in, I feel like that is sufficiently covered in 406E. With respect to the plugged hole markers, our rules actually require that there's a cap welded onto the top of those that includes the name of the well and the lat long coordinates, I believe. So it becomes sort of a monument that's capped off.
Thank you, Mr. Brown. Sorry, I didn't see that particular bit about the requirement of the capping, and but I appreciate that. If that is already part of our requirements, then I think I'm good given the places that you pointed us to.
And I'll look for a rule citation for that plug-in and abandonment marker.
Further discussion? Thank you, Director Murphy. Who wants to lead discussion into broader riparian setbacks or buffers? Commissioner McGowan?
Well, thank you, Mr. Chair. I don't know if I want to lead a discussion. I just feel like we've had a lot of testimony and feedback about a broader kind of buffer for a wider trying to think of the word I want to use, a wider variety of bodies of water, perhaps riparian areas. And I don't know if I feel confident that we've had a chance to really go through and figure out what an appropriate amount would be and for what all types of water, et cetera. So I did want folks to know that I definitely heard that testimony. I just don't feel comfortable picking or choosing an amount for all these different types of bodies of water, and just seeing how difficult it was for us to figure out what to do with fish and just the fish. I just don't think we're prepared to have that bigger discussion, but that's for me personally, and then other commissioners may feel differently.
Commissioner Messner?
Thank you, Mr. Chair. I think we've heard clearly from both industry as well as conservation groups and other stakeholders that they're more than happy to engage in a work group or a stakeholder process to look at riparian corridors and understand the potential impacts of oil and gas operations on those, and work through developing information that could inform a future rulemaking series. And I'm certainly in support of that. I think that there was clear testimony through this rulemaking series about the sheer volume of percentage of wildlife that happens within these corridors, and the need to protect them from potential impacts, particularly, well, all across the state. And so I would support that conversation to inform a future rulemaking process.
Chair.
Director Murphy.
Thank you. Commissioner McGowan, would it help to make sure that the SPP is clear that the technical work group is not just considering the aquatic habitats included in 1202C? And to be clear, I'd always thought of it as being a broader consideration, kind of more of a framework. But I certainly have never articulated that.
Commissioner McGowan.
Yeah, yes, I think that would be helpful, and then would be clear kind of that we want to have that conversation. Thank you.
I'm supportive of this as well. Thank you. Not seeing anything more here. Do we want to talk about the engaged local government piece? Commissioner Najapa.
Thank you, Mr. Chair. I brought this one forward, and I didn't have it in my notes specifically where Adams County had suggested that. So if other commissioners happen to have that, but I in looking at I know it was related to compensatory mitigation in particular. And so looking at the rules, it seems like either in A, let's see here. The language right now is, just talking about in high priority habitats, the operator will complete compensatory mitigation, et cetera, and so on. And then towards the end, it says that the director, after consultation with CPW, will have discretion to determine whether compensatory mitigation proposed is sufficient. Potentially could just add after consultation with CPW and relevant local government, but then that's making that the director's job. So I'm not sure that that's appropriate. And the other place I thought was in B, where it's talking about the operator chooses to cause or complete compensatory mitigation. And then there's a bunch of different things. And B1B there is coordination and concurrence with CPW. Perhaps we could add another letter that would be coordination and concurrence with the relevant local government. So I just put those both on the table to see what folks think is best.
Commissioner Gonzalez.
Thank you, Mr. Chair, and thank you, Commissioner Nanjapa. I had given that a lot of thought going into Monday over last weekend. And one of the concerns that kept on kind of nagging at me that popped in my head is that what if the compensatory mitigation that's determined by CPW is outside of that relevant local government? I can imagine a scenario where that relevant local government through consultation may try and influence having that compensatory mitigation occur in their own jurisdiction. And I become a little bit concerned about that being more of a motivator than strictly finding the appropriate compensatory mitigation projects and applications that CPW would be the appropriate expert to decide on statewide. So that was kind of my biggest concern about the compensatory mitigation consultation when I was thinking about Adams County's proposal in that regard.
Commissioner Messner.
Director Murphy, if you had something, go ahead before me.
So we have an incredible team of people, right? And AAG Stafford really shone through sending me language that I think makes a lot of sense in the SBP that helps capture the importance of engaging our local partners, but not putting staff in the position of getting inconsistent directions from a local government and CPW who are our partners. So I'm going to put it on screen because I think it also ties in nicely with the conversation that Western rural local government started around conservation districts, and that it's good input. And so I'm very excited about this, and I'll stop talking and just put the language up there.
I like it. Anybody have any concerns with it? Thank you, AAG Stafford. Thank you, Director Murphy. Director Murphy, do you feel you need additional direction on the SBP clarifications?
I think the first one is a little bit generic. I don't know if it's to like say, yes, staff, what you put together on the biological resources work group was the right direction, make sure that gets in there, or if it's staff, we like where you started, but we needed you to build a little bit more into it. I think that the remaining 2 and 3 feel fairly clear to me to implement. And I think that the clarification in 5, which is what I captured when Caitlin was screen sharing and Commissioner Najapa went through one of her additional SVP clarifications, that as of now, the automatic consultation under 309E2 is only really specifically tailored to wildlife, but the work group needs to consider how we integrate non-wildlife species. I think that's a component of adding that clarification to the biological resources work group, but I don't know if it's the only one. And all that to say, Commissioner Najapa, how I would interpret folding 5 into the statement of basis and purpose is in the context of the biological resources work group.
Commissioner Najapa.
Thank you, Mr. Chair. Thank you, Director Murphy. Yes, on number 5 as being part of the discussion of the biological resources work group. I guess I was, I didn't see where we had covered that yet, or although I guess maybe we haven't seen the most recent SBP. So if that's addressed, you know, that's great. I mean, just really the number 1 there was more about just confirming that we have something in the SBP saying that we are gonna have a work group that will look into this. Okay, that's great.
Yeah, I apologize, Commissioner Najapa. I didn't get to the point where I think we had really concrete language by Wednesday. And so it was bullet points in a slide that we'll build out, and we'll get to you to review as soon as we can tonight or tomorrow morning. So with that, Chair, I think I have pretty good guidance on the clarifications, but if commissioners want to add specific color or context, I'm happy to take that as well.
Any further color context clarifications from commissioners before we turn these things green? Commissioner Gonzalez.
Thank you, Mr. Chair. Not trying to hold things up here, but I'd like just a bit more clarification on what number 5 is intended to, what automatic consultation we're talking about, and what is a non-wildlife species?
You want me to take
Commissioner
that?
Nanjapa? Yes.
I'll leave it to Director Murphy. I mean, I guess my intent with that was that the automatic consultation that already occurs under 309 E2F, maybe, I think, I can't remember. So that one is, yeah, somewhere in E2. And we had some additional clarification that they added in the red line about the critical habitat, and even when there's not known occurrences. But I clarified with CPW in our deliberations that that is only regarding wildlife, or because CPW is the one that's looking into this. They're only looking at the wildlife species. They're not looking at the plant species. So that's where the number 5 kind of fits in with the biological resources, and how we then, and I guess invertebrates for that matter too. We didn't even really talk about that, but I do think that's another piece of all of this in the biological resources that we'll have to address. Does that help?
Commissioner Gonzalez.
That does help. Thank you.
Director Murphy.
As I added some clarifying language to it, I realized how much of number 5 was written in code. So.
Made perfect sense to me.
It's bad news, Commissioner Nanjapa, if you're in my brain. With that, I think that we have sufficient directive in this document that staff can go back this evening, finalize rule edits, and get the statement of basis and purpose for the 1200 series turned around just as quickly as we can. I will say that I would rather get a slightly less perfectly proofread SBP out on the 1200 series to get content out sooner. So if there are typos in it, please forgive us. We will catch them as we incorporate other people's feedback. But the idea for me would be to turn the rules around first and then just get the SBP turned around as quickly as we can. But I do think we have sufficient directive based on this document. I would be happy if the commissioners and if AEG Davenport is comfortable adjourning until Monday morning on this rule series, and we can start with 8, 9, and 12 Monday morning and then go to 2 through 6. And hopefully, I'll do a happy dance. It's an incredibly proud moment. So.
AAG Davenport, do you have any guidance for us on next steps?
Mr. Chair, I'm fine with the director's suggestion to adjourn until Monday. Just a couple of points I want to highlight for the commission. You're not taking, at least if you take the director's suggestion, you're not going to be doing a preliminary final vote right now. I think that's appropriate given that you haven't seen final rule language yet. I also recommend that you do not close the record right now in order to allow for substantive discussions Monday on the rule language and things like that. So a slightly different process just because of where we are right now, but I think all that's needed is a motion to adjourn.
To Monday morning at 9 a.m.?
I believe that's the plan, yes.
Director Murphy, are you good with that plan?
Yes, sir.
All right, well then I think that's what we're looking for, knowing that we all have, unfortunately, very busy weekends ahead of us. We still are working through the 800, the 900, we'll work through the 1200 SBPs, we'll get the 1200 rules that we'll need to go through one last time. And we all have been hard on reviewing the 2 through 6 SBP with the edits that were made there as well. So another weekend bites the books, but hopefully we'll get to a good spot on Monday morning and be in a good place to do that happy dance. Do we have a motion?
Motion to adjourn to Monday morning, November 23rd at 9 a.m.
Second.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? All right, thank you. Thanks, everybody. We'll see you Monday morning at 9 a.m. Before we go, real quick, Director Murphy, these documents will also be posted on our website as they are developed over the weekend. So if folks want to monitor the website and want to look at the documents, you'll have access to them. I would anticipate that we also would get them out to our stakeholders via email or via link or something. So that's out there for everybody as well. All right, we are going to adjourn. Thank you all.
Thanks, everyone.